Okay. If I need something, I'll just text
Yeah.
you.
Is Trish coming in this year?
Mm-hmm, yeah, she's parked already.
Oh.
It's the connector.
Oh, yeah, I'm up. I don't know if we need the system on.
Hmm?
I was telling them they might want to turn the system on.
Yes.
That's just for you, if you need it.
Big time. Thank you.
You're welcome. Are you having trouble connecting?
I'm connected now. You want to talk? Yeah.
Okay.
go for it.
Oh, but we're good for today. Okay, yeah, no, I just.
They're going to talk to the supervisor about that.
Thank you, Judge.
2017 CR 1505, Otis Tyrone McKane, here for the state.
Matthew Howard for the state.
Lauren Summeller for the state. James DeWiggins for the state.
Defense.
Sarah Brandon with the Office of Capital and Forensic Writs on behalf of Otis McKane.
John D. Maffey with the Office of Capital and Forensic Writs on behalf of Otis McKane.
And Otis Tyrone McKane is present in the courtroom, is that right?
Yes.
All right. So this is a writ hearing, is that correct?
Yes.
All right, you can proceed.
Your Honor, we have just a couple quick housekeeping matters. One is, just so everyone can plan for today, the way our witnesses schedule and lineup shook out is we do expect today to be a little bit shorter. We don't expect needing the full day. Just wanted to kind of give everyone a heads up on that. And we would like to start by moving in some applicants' exhibits, and then from there ask to do a brief opening and then move to putting on our witnesses for today.
Okay. Now, we do have a full trial docket, right? So we do have lots of cases that we're dealing with beyond this one. We have set aside a particular period of time to hear this case. I would rather utilize every day that we have available for this as much as we can.
I understand, Your Honor.
So I
Yes.
prefer to go today till 5 if that's possible.
We have experts flying in today. We can see when they come in, but we do expect to utilize the full time for tomorrow and Monday and Tuesday. All the time set aside, the rest we do expect to be used.
Okay, and hopefully today as well.
We'll do our best.
Thank you. State?
Judge, we have a couple of housekeeping matters to take up as well. But before we get to that, I don't know if you want to cover the exhibits that they mentioned just a moment ago to kind of keep it in order there.
Okay, let's go ahead and do that then. Defense?
Your Honor, as part of our habeas application, we had included 108 exhibits, and we would first move to admit applicants' exhibits 108 into the writ record.
Judge, the state has had the opportunity to review that exhibit, and we have no objection.
All right, it's admitted?
And Your Honor, may I approach?
Yes.
Your Honor, this is applicants' exhibits 109, 110, 111, 112, 113, 114, 115. These are new exhibits that we would like to move in, so applicant moves to introduce applicants' exhibit 109 through 115.
And Judge, we have copies of those exhibits here. We've had the opportunity to review those exhibits, and we have no objection.
All right, those are admitted.
Your Honor, I expect a couple of times we may need to approach a witness. Would you like us to ask permission to approach witnesses each time?
Yes, just to make sure the record is complete.
That's all I have.
And Judge, just a couple of things from our end, and this is just to make sure we explicitly state it on the record. We'd like the court to take judicial notice of the clerk's file from the original proceeding and the clerk's file as it exists for the writ proceeding.
All right, the court takes judicial notice of all of that.
We'd also like the court to take judicial notice of the record from the time of the original proceeding as well.
The court takes judicial notice of the entire record.
And finally, Judge, at this time, we'd like to invoke the rule for any witnesses that are currently in the courtroom to be instructed that the rule has been invoked.
All right, what I'll do, the rule's been invoked, so what I'll do is I'll instruct both sides to make sure that your witnesses understand the rule and explain to them and that they comply with it accordingly.
Thank you, Judge.
All right.
We've all had the experience of feeling misinterpreted or misunderstood. Perhaps something we said was taken out of context, or someone didn't take the time to get to know you. It's an awful feeling. When someone thinks they know something about you, something you did or said, and then has a bad impression or judgment about you. It's painful when someone has a judgment about you that's wrong and that isn't representative of who you really are. Imagine that feeling when the stakes are at their highest. Definitely a case where defense lawyers are tasked with telling jurors the story of their client's life, and jurors are tasked with making one of the most difficult decisions in theirs. Our post-conviction team, including myself, have had the honor and pleasure of getting to know Otis McKane, who he is, his life and his experiences, his family, his friends, his struggles, but also his heart. But the jury at his capital trial did not, and that is because his trial counsel did not. Mr. McKane's trial team had a legal and ethical obligation to undertake as full investigation as possible into their client's life. They were required to talk to people across his entire life, collect as many records as possible with their client's name on it, investigate his family's history, retain experts tailored to help tell their client's story, and present a full portrayal of Mr. McKane's life. They did not. With little investigation into their client's life, the result was a penalty phase riddled with errors and misrepresentations. These falsehoods replaced the facts the jury should have heard in this case. In this hearing, the court will be reminded of the story that was told at trial. The prosecution, for their part, told the jury that the offense was premeditated and that Mr. McKane is a diagnosable psychopath. There were two main ways the prosecution accomplished this. One, by completely misinterpreting the contents of Mr. McKane's cell phone. And two, by presenting the testimony of a psychiatrist who was willing to lend his purported credibility as an expert to label Mr. McKane with the most prejudicial names someone can be called at their death penalty trial: antisocial, sociopath, psychopath. This court will hear evidence during this hearing that both of these were significantly flawed and misleading, but trial counsel challenged none of it. Regarding the cell phone, this court will hear that the prosecution wildly misunderstood the contents of the cell phone. Our phones have a mind of their own these days. They're constantly capturing images and data we may never see or even know about. That happened in this case. The vast majority of the contents of the prosecution gathered from Mr. McKane's phone and presented at his trial was generated and stored without his knowledge. The best example is this: an image of an officer slain in California near the time of this incident. At trial, the prosecution portrayed this as a Google search and as evidence of Mr. McKane's premeditation and hatred for cops, something that would carry great weight with the jurors sitting in this type of case. But that evidence presented was wrong. Our phones have all kinds of applications, and if these are opened and even running in the background, they are constantly capturing images without our knowledge. And within seconds of Mr. McKane's phone capturing the image of that officer, the open application on his phone that was running in the background also captured tons of irrelevant other images, such as a golfer, a football player, and logos of Pfizer and Mobil. The application ultimately captured hundreds of images and saved them to Mr. McKane's phone with no intention on his part. The prosecution also insinuated to the jury Mr. McKane saved dozens of photos of guns on his phone, intentionally researched a gun show that was happening in Texas, and purposely collected and saved images of Detective Marconi. But this court will hear that the state's analysis of this evidence was also deeply flawed and severely overstated the significance of the cell phone data to the jury, but was still used to convince them to sentence him to death. Now, the psychiatrist the state presented, Dr. Michael Arangula, there is no other way to say this than point blank, that psychiatrist's opinion was totally unmoored from any of the scientific and ethical principles that guide good psychiatric opinions. And because the state fed Dr. Arangula its theories about the cell phone evidence, the data he based his opinion on was also flawed. With the misrepresentations of the cell phone evidence and Dr. Arangula's opinion in hand, the jury was told a story about a person who fit a stereotype that the state knew the jury would fear. They told the jury that Mr. McKane has the same diagnosis as Charles Manson. By the way, Dr. Arangula's opinion was also based on his willingness to tell the jury he knew all about Mr. McKane, a man he never met. There was another psychiatrist the state hired, however, one the jury never heard from, one who did take the time to interview Mr. McKane personally, who used a methodology principled and based on science. And while the jury didn't get to hear that testimony, this court will today. That expert's name is Dr. Matthew Fabian. And this court will hear from Dr. Fabian that he spent several hours with Mr. McKane, asked him all kinds of open-ended questions, dug into Mr. McKane's upbringing, his family, and even his criminal history. Dr. Fabian will tell this court that based on his decades of experiences treating individuals with personality disorders, simply put, Mr. McKane doesn't have antisocial personality disorder. This court will also hear from an expert in risk assessments and personality disorders. Dr. John Edens has dedicated his life's work to ensuring that mental health experts rely upon sound methodology when making predictions about human behavior. His research into psychopathy and the prejudicial effects of that label on jurors will reveal to this court that when that label was used in this case, Mr. McKane's fate is signed, sealed, and delivered. This expert will also tell the court that the prosecution psychiatrist went rogue. There isn't research, peer-reviewed articles, or science to back up his opinions, even though he told the jury there was. The problem with Dr. Rainbow's testimony is that jurors, whether they intend to or not, tend to fall back on stereotypes of what they imagine serial killers and psychopaths are. And they use that in deciding the special issues in death penalty cases, the future danger issue and the mitigation issue. And prosecutors know this about jurors in death penalty cases. And that's why they presented the testimony of Dr. Randula, someone willing to give them the label they wanted without even ever asking to meet Mr. McKane. In all of this, the flawed cell phone testimony and the flawed psychiatric testimony went completely unchallenged by trial counsel. Even though the state disclosed the cell phone discovery years in advance of trial, it is remarkable to stand here and say that the stated reason trial counsel gave for not looking at the cell phone data in this case was because they couldn't open it. They told the court that because they couldn't open it, they assumed the state couldn't open it, even though the state laid out for them exactly in their 404B notice what they intended to do with the cell phone contents. And based on the state's use of the cell phone evidence at trial, the mistake was obviously disastrous. This court will hear evidence at this hearing that counsel had every opportunity to find a way to open the discovery, work with an expert to understand how certain contents got on Mr. McKane's phone, and be prepared to challenge the admissibility or at least the weight of it. And by not investigating their client's life, they left themselves with little to share with the jury about him, the things he cared about, his dreams, the things he struggled with, and how eventually he grappled with mental health issues no one saw coming. By the end of this hearing, this court will hear evidence of a full, humanizing portrayal of Mr. McKane's life story and struggles with mental illness were not told at trial. How did this happen? Because trial counsel did not spend enough time with witnesses or their client. This court will hear that a proper mitigation investigation requires meeting witnesses in person in a place they're comfortable with. You ask them open-ended questions. There's a saying, you have to meet witnesses where they are. That means don't judge them. Don't make demands of them. Be patient, build trust, ask them their stories and details of what they can offer to learn about your client's life. The mitigation investigation must also be done immediately upon trial counsel's appointment, so these critical witnesses are contacted right away and trust can be established with the defense team. I want to assure this court that clients with mental health issues and family witnesses that struggle to open up, those are normal. Those are expected and anticipated in every capital case, and they are rarely insurmountable. But the things capital defense teams are trained to do to build relationships with clients and important witnesses was not done in this case. The court will hear evidence that in the first 6 months of trial counsel's appointment, no mitigation investigation was done. They didn't even hire a mitigation specialist. And when the team finally hired one 6 months into their implementation of Mr. McKane, she spent the next 3 years doing nothing even close to resembling what a mitigation investigation should look like. Hardly any witnesses were spoken with, hardly any records collected. There are no memos or research to reveal substantive work product that should represent 3.5 years of work. The team replaced that first mitigation specialist with a second one, Dr. Wandelman Taylor, and the court will hear from Dr. Taylor herself that even her mitigation investigation hardly got off the ground. One of those reasons, of course, is the pandemic in March 2020 that we all know lasted much longer than anticipated. Witnesses were understandably reticent to talk during that time. But Dr. Taylor kept in touch with those closest to Mr. McKane and managed to build good relationships with the family, finally. They liked her, they trusted her, they shared things with her. But the trial team was at best disinterested in the mitigation investigation she tried to conduct. In fact, this court will hear that in this case, Mr. McKane's trial lawyers didn't even inform their mitigation specialist when trial was set. She had no idea when her deadlines were and no one checking in on the status of her mitigation investigation. This court will hear the circumstances of Dr. Taylor leaving the team and how the trial team asked a fact investigator's wife to step in. And that between May and September, in the months that should have been the last exhaustive effort to mine all evidence possible about their client's life, Carol Parker worked 56 hours. Most of that included running witness locates for witnesses she would never talk to and attending trial. And so what happened? In the penalty phase, trial counsel's inadequate investigation resulted in them unable to challenge the state's narrative, but also telling their own half-truths. You see, trial counsel chose an easy road from the outset of this case instead of doing meaningful investigation. Like ticking off boxes, they decided, let's blame the mom for how she raised him, and let's blame him for using drugs. But trial counsel didn't investigate enough to know if those things were true. And so in taking this approach, trial counsel totally missed Mr. McKane's true character and person and the signs their client suffered from serious mental health issues later in life. This court will hear evidence that Mr. McKane's family and friends universally describe him as sweet and caring, someone who loves his family deeply and has respect for his mom and sisters and aunties and his coaches. One teacher shared with us that he even considered adopting Mr. McKane in high school to help him escape poverty and violence in his neighborhood, all because Mr. McKane was a good kid with a bright future. The court will also hear that as Mr. McKane entered early adulthood, he struggled. Work was hard. Seeing family and friends became hard. Getting out of bed, putting on clean clothes, and combing his hair was hard. He obsessed over and drew pictures of aliens that would save our planet, accused his best friend and closest cousin of having an affair with a girlfriend they barely knew, and spent days alone in his room drawing his pictures and talking to a person that wasn't there. This court will hear from Mr. McKane's sister, Tasha, who witnessed her brother's struggles and was willing to tell the jury about them, had trial counsel built the relationship with her and asked her to testify. And finally, this court will hear from Dr. Scott Bender, who reviewed Mr. McKane's extensive life history the post-conviction team put together. And that included extensive social history records and nearly 24 lay witness statements. Dr. Bender also personally interviewed Mr. McKane. Dr. Bender will tell this court that Mr. McKane has a serious mental illness that causes him to experience delusions and paranoia, even about the people in his life he loves. But the jury never got to hear about this. In a death penalty case, we have to ensure clients receive competent representation by lawyers equipped to handle these serious cases and who are willing to take on the extraordinary investigation they're duty-bound to do. We have to ensure the jury knows what a person's life has been like before deciding to extinguish it. This court can only have confidence in the outcome of the jury's decision if it has confidence the jury received a whole and true picture of Mr. McKane's life story, his intentions, and his mental health. But the jury in this case didn't have that whole and true picture, and at times were fed misinformation. But things can be corrected now. There is an opportunity for this court to receive the evidence the jury should have had, the facts the jury should have had when making their impression of Mr. McKane. This court has a lot in front of it already, including our post-conviction application that raised several grounds for relief, and now over 100 exhibits in support of those claims. This hearing, however, is going to focus on the errors at the penalty phase of Mr. McKane's trial. And so at the end of this, I believe the court will see that Mr. McKane received ineffective assistance of counsel, the state presented misleading evidence at his trial, and I believe the court will grant Mr. McKane a new trial.
All right, State?
Just very briefly, this court is well aware of its role in this process, and Judge, I know I don't need to remind you of how habeas proceedings work. I know that, in a very real sense, we're here to build a record on this, and ultimately the decision will go to the Court of Criminal Appeals. That decision is made without emotion. That decision is made in an objective way. That decision is also made with the knowledge that once you get to this phase, the burden of proof shifts. The burden of proof is no longer on the state to show why Mr. McKane should be convicted or why his punishment should remain as it is. The burden is on Mr. McKane to come in and prove his claims. Under Maldonado, it is on the applicant to plead and prove facts which true would entitle him to relief. Under Ex parte Envy, the bare conclusory statements, sworn statements of the applicant are not enough. It has to be backed up by evidence. It has to be backed up by proof provided to this court. An applicant must plead and prove facts which entitle him to relief and must prove his claim by a preponderance of the evidence when it comes to everything other than actual innocence, and that's from Ex parte Reigns. There is a lot to break down with this particular case, but we're really talking about a few separate types of claims. The one that we anticipate that you're going to hear the most about, or the type that you're going to hear the most about, is ineffective assistance of counsel. This court is well aware of the standard that applies to ineffective assistance of counsel under Strickland v. Washington. First and foremost, that reasonableness standard, or that objective standard. Was it objectively unreasonable for counsel to undertake this action? Did counsel perform below the industry standard of what would be expected of attorneys in a similar situation? We do not believe that the evidence exists or that there is proof that counsel in this particular case was below that industry standard. We believe that in the evidence the court has already heard and in the documentation that the court has already received, that it has been shown that counsel has met that industry standard or did meet that industry standard at the time of the original proceeding, and we believe the evidence will show that. The second part of that Strickland standard is that it has to be that but for the errors of counsel, the outcome of the proceeding would have been different. And we do not believe that the evidence that is shown to this court will support that conclusion, that the outcome would have been different. We believe that that cannot be met, that burden cannot be met by applicant here. As to the notion of false evidence, there are two parts to a false evidence claim as well. The court's well aware of that under Argus and Giglio. The notion that first and foremost, for that first prong, you have to be able to show that the evidence was in fact false. It's not a notion that the evidence could be false or the possibility that the evidence is false. It is proof that this evidence is false, was in fact false. We do not believe that the evidence will support or that the proof provided in these hearings will show that that evidence was false. If the individual can show that that evidence was false, though, then we move in to a second outcome determinative prong. But for that evidence, would the outcome of the proceeding have been different? Would it have changed the outcome for the punishment faced in this case? Understanding all of the other evidence, understanding the totality of what this court and what the jury heard, would it have changed the outcome of the case? And we do not believe that it can be shown that it would have changed the outcome of this case. Ultimately, Judge, we are here to build a record on this. We know that you will be making a recommendation to the Court of Criminal Appeals. We know that you're going to be making credibility determinations, and we hope to do everything that we can to help you create that record and help you make those credibility determinations and to come to the correct recommendation there. We will do everything we can to hold applicant to his burden under Maldonado and under Raines. And we believe that the evidence does not support and cannot support the claims that are being made on this application. Thank you.
All right.
Can petitioner proceed with the presentation of witnesses?
Yes.
The petitioner calls Ana Juarez.
I'm going to swear you in, okay? Yeah. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you may need to adjust the microphone, the whole thing, make sure we can hear you, okay?
Okay. Can you hear me?
Can you give us your name and spell it for the court reporter, please?
Ana Juarez, ANAJUARZ.
Thank you, Your Honor. So, Ms. Juarez, I just want to start with some background information about you. Where do you live right now?
San Antonio,
How long have you lived in San Antonio?
my whole life.
Where'd you go to high school?
Fox Tech,
And what year did you graduate from Fox Tech?
2006.
After high school, did you attend any further schooling?
St. Philip's and Our Lady of the Lake University.
What did you study at those schools?
Bachelor's in psychology and criminal justice, and then master's in social work.
And where in San Antonio do you work right now?
Bear County Jail.
And what do you do at the Bear County Jail?
I'm a social worker there.
How long have you been employed that way?
3 years. I've been there 3 years.
Okay. So let's talk about why you're here today. Do you know someone by the name of Otis McKane?
Yes, sir.
How do you know Otis?
We met in 10th grade.
Okay, so about how long have you known him then?
That's over close to 20 years. Over 20 years.
This is something I've vicinity, yeah. And just to be clear, the school that the two of you went to was Fox Tech?
Correct. Fox Tech.
And where was Otis in relation to you?
He was in 10th grade because he graduated. Yeah, I think 10th grade. He was he was a year above me, so junior.
Okay, all right. So I want to talk for a minute about Fox Tech. Where in San Antonio is Fox Tech located?
Like almost in downtown area.
And as a school, what is Fox Tech like?
What do you mean?
Demographic-wise, what's the student body at Fox Tech like?
So they used to pull from like the east side of San Antonio and the west side, but the two areas were mainly like poverty areas. So most of the population there was income, like the income wasn't great. High rate of pregnancy, things like that there.
Was there much funding for facilities and textbooks and things of that nature?
No, that wasn't one of the good schools to go to.
So let's talk about your friendship with Otis. You mentioned that you weren't in the same year as Otis. How did you end up getting to know him?
Just through other friends, and we played sports as well.
Okay. What were your first impressions of Otis when you started to get to know him?
Well, he was friendly. He was very calm. He wasn't aggressive like other guys in school. He was like a nerdy but cool guy. But yes.
And you mentioned this a little bit, but how did Otis's behavior towards you compared to other boys his age at Fox Tech?
Oh, just calm, very friendly, and not aggressive towards just like other guys at the school at that point.
Mm-hmm. What did Otis look like back then?
So he was very attractive, very clean, took care of himself very well. He played sports, so he was one of like the top guys in the school. So he took care of himself.
Mm-hmm. Did it seem like he took pride in the way he looked?
Yeah, definitely.
Did he have any particular haircuts or?
No, I mean, he was just always really, he looked nice all the time. He took care of his haircuts, you know, that was important to them.
Was there at any point when you were interested in potentially dating Otis?
Yes, we were talking for a little bit.
Do you know if Otis was interested in dating you?
Yeah, I think so.
Were there any other boys that you were interested in at the time?
Yes, there was another individual that I also spoke to in 10th grade.
So that around the same time you're interested in both Otis and another guy?
Correct. Yes, sir.
How did that love triangle play out?
Not great. We used to, everyone at the school would go to this recreational Tobin Center, and I was there with the other guy in high school, just for like a basketball game, and Otis was there and he came to say hi, and then the other guy, which was more of a bad boy, tried to make fun of Otis, try to call him out, made fun of him for, you know, me be there with him. So I felt pretty bad, but.
And so, yeah, so just to be clear, at that point, you had decided to go with this other
Correct.
kid instead of Otis?
Yes, sir.
Okay. What was Otis's reaction to that guy calling him out in front of everybody else?
I think he was embarrassed, but he was just trying to calm him. He was trying to calm him down. He was telling him, "I'm just trying to say hi. Like you know, I'm not trying to start nothing." But the guy, I think, because all his friends were there, he was trying to get him to react and, you know, I guess fight.
Yeah, trying to pick a fight with Otis.
Yeah. Mm-hmm.
Did Otis engage and get into a fight with him?
No. Otis walked away. He tried to calm it down, and he was like, "I'll just see you later," and he just walked away.
After that point, did you have any conversations with Otis about you picking that guy over him?
Yes. When I saw him at school, I thought he was going to be mad, or maybe, you know, say some mean things. But he told me that he understood that, like, we're all allowed to have our feelings. He's like, "I understand that that's who you want to be with." He's like, "We could still be friends," and we stayed friends.
Yeah, and why did you stay friends with Otis?
Because he was really sweet. He was very kind and very understanding. I mean, after that, you would think most guys would respond in an ugly way, but he didn't.
Okay. So you mentioned before that Otis was involved in sports. What sports did Otis play?
Basketball and football.
And how was Otis as an athlete?
Great.
Yeah.
One of the top athletes at the school. Mm-hmm.
Was he passionate about sports?
Yes, very passionate.
Would you say that he was involved in the team dynamic on his sports teams?
Yeah, definitely. That's what kept them together. That's what kept them going in school.
Mm-hmm. Was Otis a troublemaker as a student?
No.
Was he popular at school?
Very popular.
How did he become popular?
Sports. Yeah, sports.
So we talked about Otis being a little kinder and nicer to you than a lot of boys his age. Was he different in temperament from a lot of the other kids?
Right. He was very calm. He wasn't vulgar. He wasn't disrespectful like some of the other guys. Again, even being turned down, he was still the same respectful, calm. And again, the vulgar part. A lot of guys at that age can be very aggressive in that way, but he wasn't.
Mm-hmm. Can you remember any specific instances of Otis being the calm and collected one when everybody else is a little hot-headed?
Yeah. There was a game, and I can't remember what school we were playing against, but most of the schools we played against, it was pretty aggressive. But someone started a fight or an argument off of something, and I just remember him trying to calm down his teammates. He pulled away like 2 or 3 guys. Then I remember, I think teachers got involved and then stopped it all together. But I didn't see, Otis was trying to pull people away, and I think, I always remember him saying it's not worth it, but I think it was because of who we were playing against.
Mm-hmm. So Otis was trying to talk down on
Right,
the guys.
and he pulled down, I think, one of his closer friends.
So I want to talk for a minute about what you know about Otis's home life while he was in high school.
Mm-hmm.
What knowledge do you have of what it was like for Otis at home?
It wasn't stable. It wasn't a strong foundation.
Mm-hmm.
There was a lot of movement going on, just not a lot of stability.
Did it seem like Otis had a lot of parental support or financial support from home?
No.
What makes you say that?
Well, I know about times where people would give him money or help him out with things, or he would stay at different places. I know Mom was a single, hard-working mom, so I think she did the best that she could with what she had in front of her. But that pulls you away from, I guess, other motherly responsibilities.
And yeah, you mentioned that Otis's mom was single and hardworking. How did Otis talk about his mom?
He loved her. I think he had a lot of respect for her. I don't think he saw where she lacked in the areas that, she couldn't provide.
That was all just normal to Otis?
Yeah, that was his reality.
So let's move on after graduation from high school. Did Otis graduate from Fox Tech?
Mm-hmm. Yes, sir.
Did you stay in contact with him after you graduated?
Yes, sir.
Why'd you do that?
Because we were friends, and he was one of the nice guys.
How did you stay in contact with Otis?
Just communicating. We would see each other here and there, phone, text conversations.
So I want to talk about some events that happened a while after the two of you graduated. Do you remember a time when Otis got into some trouble in Concho County?
Yes, sir.
Do you recall what happened?
I think it was like a drug charge.
How did you find out about that?
He reached out, and then I talked to Mom about it too.
Was there anything that you did for Otis while he was in jail in Concho County?
Yeah, I sent him money, and then we went to go pick him up when he was being released.
When you say we, who's...
Oh, me and his mom.
Okay. So you ended up giving his mom a ride to Concho County?
Correct.
About how long is the drive to Concho County?
I think about three hours.
3 hours one way?
Yeah, correct.
How did Otis react to you giving his mom a 3-hour one-way ride to pick him up?
He was very thankful, and he kept saying, if there's ever anything I need, he would be there for me.
And I guess just to back up, why did you give his mom a ride? Why did she need a ride?
I remember correctly, she didn't have the vehicle or a working vehicle to get there, and he didn't have a way of getting home. He didn't have money. So.
When you did that, did it seem like a big gesture on your part?
No.
But Otis was very thankful?
Yeah, Otis was he felt bad that I even had to do that, but it was okay.
So as the years progressed up after high school, did you begin to notice some changes in Otis?
A lot of changes.
In terms of his physical appearance, how did Otis change from that kid that was well dressed in high school?
He didn't take care of himself as much as he used to. Clothes wise, shoes is very important to gentlemen, and I remember seeing his shoes and they weren't as clean, and I was like, man, I know that's something he took pride in. He didn't take care of his hair the way he used to. He didn't look like Otis.
In terms of talking and speaking with Otis, were there changes in the way that he spoke?
Correct. Yes, I feel like there was a slower speech pattern, delayed thought process. Sometimes it took him a second to put his thoughts together. I think he couldn't articulate himself as quickly as he used to.
Over time, did Otis get better or worse?
Worse. Worse.
Were there any particular things in Otis's life that it seemed he really struggled with? Yes.
I know financially that there were struggles there, but also he was in a very toxic relationship. And again, his impaired thought process, things changed there with how he viewed the world. And I feel like he detached from for me, I guess for myself, he detached, and we didn't communicate as much as we used to, but there was really no clear reason why.
And so Otis was not reaching out to you to speak?
No.
You mentioned a toxic relationship. Who was the toxic relationship with?
His child's mother.
Was Otis in high school the kind of guy that had toxic relationships?
No.
Did you ever speak with Otis about trying to get visitation with his child?
Yes, we spoke on it, that he was just distraught that he wasn't able to connect with his child.
When you spoke with Otis, did you talk about, well, I'll withdraw that. When you spoke with Otis about not being able to see his child, how would you describe his demeanor?
A lot of mistrust, a lot of paranoia, a lot of I want to say disconnection with reality, if that makes sense.
Yeah, did you try to talk Otis through some of that paranoia?
Right, like logically break things down for him.
Did it seem like Otis was able to be talked through that paranoia?
No, not at all.
I just have a few more questions about your thoughts on Otis during this period of his life. So we discussed earlier that you're a social worker at the Bear County Jail, right?
Yes, sir.
In that role, have you had the opportunity to interact with people struggling with mental health issues?
Yes, sir.
Looking back on your interactions with Otis during that time period, did his behavior remind you of anything?
Yes.
What did it remind you of?
Someone like that, we probably would have in a more like a mentally ill unit.
I want to finish up by asking you about Otis's trial, okay? Did you see any of Otis's trial?
Yes, sir.
When you were at the trial, did you see any of Otis's old friends from high school?
Yes, sir.
Do you remember who you saw?
Reginald and Maurice.
Did you ever meet anyone from Mr. McCain's or from Otis's defense team before trial?
No, sir.
Are you aware of whether or not any of them ever tried to reach out to you?
No, sir.
When did you become involved in Otis's case?
When I was reached out to someone after his conviction by y'all's team.
If someone had contacted you before Otis's trial, would you have shared with them what you shared with the judge today?
I would have shared a lot. Yes, sir.
Would you have been willing to testify at Otis's trial and say what you said today to the jury?
Yes, sir.
Ms. Waters, was it easy to see Otis change the way he did transitioning into adulthood?
No.
Was it surprising to you when you found out that Otis had been charged with this offense?
Yes, sir.
I'm sorry, there is a box of Kleenex behind the screen right there.
I see it right there. Yes, I was surprised.
Have you continued to stay in contact with Otis?
Yes, sir.
And after all you saw him change, after all that you saw change in him, and after all that's happened, why do you still keep in contact with Otis?
Because I care about him, and I know the good in him.
Judge, I have nothing further. I'll pass the witness.
Thank you, Judge. Ms. Juarez, my name is Matt Howard. Can you hear me all right?
I can hear you. Yes, sir.
Okay, we're not using the mics up there
Okay,
this morning.
I can hear you.
I just have a few questions for you. So you mentioned that you've been working at the jail for about 3 years as a social worker.
Yes, sir.
How many, I don't know, would you call them clients?
Patients?
Patients?
Oh,
Okay.
sorry.
How many patients would you say that you interview regularly?
On my caseload or
Yeah.
daily?
Yeah, let's say daily.
I see about 10 to 17 a day.
Okay. And when you're interviewing those 10 to 17 patients, are you diagnosing issues that they may have?
No. So that's the assessment part when they're initially coming in. We're doing all symptoms and then notating for the psychiatrist.
And so you notate the symptoms and then it goes to a medical professional to make the official diagnosis?
Correct, sir.
Have you had do you know after the fact then?
Yes, sir.
What the result of the diagnosis is?
Correct, because we continue to follow up with them if they're on our caseload.
Have you had an instance where you have diagnosed certain, or not diagnosed, but identified certain symptoms that you feel like are consistent with the diagnosis, but then it comes back with a different diagnosis?
Yes, sir.
How often has that happened?
I don't know. I couldn't give you a number and then be honest with it.
Okay. I appreciate what you're doing at the jail, and I'm not trying to make light of it in any way. But when you interview someone, are you looking for certain symptoms or certain tells about some sort of mental issue that they may be having?
Yes, sir.
And how often would you say you're able to identify those in the clients that or in the patients that you're interviewing?
Almost every time.
Okay. So every interview that you're doing, you're able to...
We're looking for the symptoms, even if they're not giving it to us.
Okay. Why, and this is going to sound like a larger question, why are you here today?
Because I care for him. He's my friend of 20 plus years.
So you care for Mr. McKane, and that's why you're here.
Correct.
Is it fair to say that you don't want Mr. McKane to be in prison?
No, that's not valid.
Okay, why is that not valid?
Because I'm not here to judge if he should be there or not. That's not why I'm here.
Okay. So do you think he should be in prison then?
I think he should have a fair trial and the jury decide for him.
Do you keep up with Mr. McKane's family today?
Some of them, yes.
Did you speak with them in preparation for this setting?
No, sir.
Did you do anything in preparation for today's setting?
Like meet with the lawyers?
Yes.
Oh.
Well, and have you reviewed anything else, done anything else in preparation for this?
No. I met with the lawyers regarding like why I'm here.
I know that your affidavit a moment ago in testimony, you mentioned noticing a change in Mr. McKane after the
Yes.
time of high school. Have
Yes,
you
sir.
ever diagnosed Mr. McKane or had the opportunity to observe in a clinical setting?
No, sir.
Judge, I guess I'd object. He didn't offer a diagnosis in his examination. I'm not sure that we need to go this far down the road in terms of our ability to diagnose. He's not being offered as an expert.
And I'm not asking about the ability to diagnose, I just asked if she had sat down and had the opportunity to evaluate Mr. McKane.
Overruled.
So that's the question. Have you had the opportunity to sit down and evaluate Mr. McKane?
No, sir. I wouldn't do that because he's a friend.
And why would the fact that he's a friend mean that you shouldn't evaluate him?
That goes against our code of ethics. We don't treat our family or friends.
That being said, your affidavit does offer an opinion as to behavior and things you observed about his behavior, correct?
Correct.
So why does your code of ethics say you can't evaluate family and friends?
Because there's emotion there, right? So we may not see things completely for what they are.
Okay. And would you agree that, like you said a moment ago, there's a degree of emotion that goes into the fact that you've known Mr. McKane since 10th grade?
Yes, sir.
I just have a few more questions for you, Ms. Juarez.
Yes, sir.
You mentioned the changes that took place in Mr. McKane after high school.
Yes, sir.
Did you form an opinion as to what could have caused those changes?
Judge, again, I guess I object, she's not qualified as an expert to offer a diagnostic opinion. She has previously testified to, I guess, a lay opinion, and that's been asked and answered.
And I can rephrase, Judge.
Okay.
Ms. Juarez, as Mr. McCain's friend, did you notice any changes in his behavior that you thought might be contributing to that change in appearance, the change that he was acting, or how he was acting?
I'm sorry, I don't understand.
Did you think that you mentioned drug use a moment ago, for instance? Did you believe that might have played a role?
I'd object, I think that's a misrepresentation of the
I don't think I
Hold
said.
on a second. Just so you know, I didn't give you these instructions,
Okay.
but when one attorney stands up and objects, don't respond at all until we let you
Okay.
know whether or not you can.
Okay.
All right, you can continue.
Judge, I guess I just asked the state to identify where drug use was mentioned in prior testimony.
And I can rephrase again, Judge.
Okay.
Ms. Juarez, you mentioned going with Mr. McCain's mom to pick up Mr. McCain from jail in another county.
Yes, sir.
Do you know what he was in jail for?
I just know it was a drug charge.
Okay. Do you believe that was kind of a turning point in as far as what you observed about him, the change between high school and the change after high school?
I don't think that was when I saw the turning point.
When did that turning point take place?
Early 20s, maybe. I can't remember, but I know I noticed the change before the pickup in the other county.
Your affidavit mentions, seems to indicate that after the time of that arrest and the assistance that you provided to Mr. McCain's mom,
Yes, sir.
that you started to notice those changes. Is that accurate?
Yes, sir.
And you mentioned that you and he were close until that point in time, and clearly close enough that you wanted to assist his mother with that 3-hour drive, and presumably a 3-hour drive back. Did you ever have a conversation with Mr. McCain about what was going on with him at that point?
I know we did, but I don't remember like what that conversation was like.
So no indication from him about what had changed in his life between high school and adulthood?
I can't remember that. Yeah, I can't remember.
Switching gears just a little bit, and this is kind of the last place that I'd like to go.
Yes, sir.
is, you mentioned a moment ago in direct testimony about the relationship that Mr. McCain had with the mother of his child, and you described that as a toxic relationship. What do you mean by that?
I just remember him telling me how they just could not see eye to eye on a lot of things, and they would cause each other turmoil, pain, name calling. It just wasn't a healthy relationship from our conversations.
Are you aware of any violence that was perpetrated in that relationship?
No, sir.
Would you be surprised to learn that there was a protective order against Mr. McCain?
No, sir.
Why would that not be surprising?
Just because I know they didn't get along very well. I knew there was a lot of turmoil there.
And is that a stark contrast to the description of that you gave of his personality in high school?
And no, I am referring to what he said she would do. So I I don't know what transpired in the relationship, but I know they didn't get along so much that she did that. I don't know the truth behind that because I don't know what happened. But if you're referring to if I personally, whatever.
No, I'm just saying, if the person on the phone is not fun, but they won't be a part of my record. Right. Unless they're just Yeah.
Let me know when you're ready.
Just one moment, please, Tom. Your Honor, we are ready to proceed.
Right, back on the record, State of Texas versus Otis McKane, or Henry Otis McKane. All right, the applicants you can consider, or petitioners.
And really quick, Your Honor, I may have made a mistake earlier. In introducing the applicant's exhibits, I intended to introduce applicant's exhibit 1 through 107 as well to be admitted.
And Judge, we spoke about this off the record a moment ago. I believe that we've seen all of these exhibits. They are already in the possession of the district clerk's office, but we'd like to make sure that they become part of the record of this hearing today and that they are included in the court reporter's record here. We have no objection to those exhibits being admitted.
All right, then they're admitted.
Thank you.
You're welcome.
Applicant will now call Dr. Matthew Fabian.
Let's see. I'm going to swear you in. All right. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? I do. All right. You may need to adjust the microphone. Make sure we can all hear you.
Is this okay?
Yeah, it's pretty powerful.
Okay.
You don't need to get too close. All right, can you introduce yourself to us, spell your name for the court reporter?
Yes, my name is Matthew Fabian. First name is spelled Matthew. Last name is spelled Fabian, Faubion.
All right, applicant.
Good morning, Dr. Fabian.
Morning.
Are you currently employed?
Yes.
Where are you currently employed?
Currently I'm employed as the clinical director for West Texas Center's local mental health authority. It's an outpatient community mental health center covering 23 counties in West Texas.
What do you do there?
So I'm in charge of overseeing all clinical services for that agency, but I also do clinical work. So Monday through Friday I see patients in that catchment area. We work by telemedicine because it is such a large catchment area. So I'll see folks across all of our clinics in all of the counties within the area.
Your Honor, may I approach the witness?
Yes.
May I approach the bench as well?
Yes.
Dr. Fabian, I'm handing you what's been marked as applicant's exhibit 116. Can you identify what that document is?
Yes, this document is my most recent CV or resume.
Applicant would move to admit applicant's exhibit 116.
No objection, Your Honor.
It's admitted.
Dr. Fabian, can you describe your educational background?
So my undergraduate education was at Oklahoma State University from 1990 to 1994. And then I went to medical school at the University of Oklahoma from 1994 to 1998, where I received my MD degree, my doctorate of medicine. Then I joined the military as a way to pay for medical school. So I came to San Antonio in 1998 to complete a psychiatry residency program, which is a 4-year program with specialized training in psychiatry. I completed that program, and then in 2002 and 2003, I went and did a subspecialty training program at the University of South Carolina in the field of forensic psychiatry. Then I returned from my time at the University of South Carolina and began serving active duty in the United States Air Force.
How long were you in the military?
I was in the military for about 10 years, 10 and a half years.
Can you tell us more about your work background in psychiatry?
So when I came back from the subspecialty training at the University of South Carolina, I was on active duty and I was stationed at what was then Lackland Air Force Base and worked out of Wilford Hall, which was the large medical center there on base. And my first job in the military was overseeing the outpatient mental health clinic. So I did that, and then in 2003 and 2004, I had my first deployment over to the Middle East. And at that time I was stationed out of a base in Qatar and had a wide-ranging area of responsibility and did a diverse number of duties on deployment. Then when I returned from that Air Force deployment, I assumed care of the consultation liaison service at Wilford Hall Medical Center. And basically what that was that I oversaw provision of psychiatric consultative services to folks who maybe were admitted to a medical unit or a surgical unit or who were seen in the emergency room. So I did that job for a while. With seniority came some promotions, and I ultimately served as the department chairperson for psychiatry there at Wilford Hall, as well as the associate residency training director, meaning that I was responsible for the military piece of the psychiatry residency training program. Then I had a second deployment in 2006-2007, during which time I oversaw a combat stress unit and also had some other responsibilities within Iraq.
Where do you hold a medical license?
I'm currently licensed in both Texas and Oklahoma.
Have you been recognized by a court before as an expert in psychiatry?
Yes.
Dr. Fabian, do you do forensic work and clinical work?
Yes.
How much of each?
About 80% clinical and 20% forensic.
What is the difference between forensic work and clinical work?
So clinical mental health work is, well, seeing patients and taking care of people. You know, I'll see folks, make diagnostic assessments, initiate treatment plans, prescribe medications. Often we'll see them over time, what we call longitudinal care, where you'll see people multiple times over time. Currently in my job duties at West Texas Centers, I see both adults and children because I'm responsible for the provision of what we call crisis prescriber services. So when folks within our large catchment end up in the emergency room or come to the attention of law enforcement and need an appointment with a psychiatrist sooner rather than later, they come see me. So I see about 70% adults clinically and about 30% kids clinically through West Texas Centers. Then the forensic work is evaluation and assessment. So I'll be asked to do, to answer a question for the court, like for instance, to render an opinion on whether an individual is competent to stand trial or not, or whether someone was sane at the time of a charged offense. So with respect to my forensic work, I not only do private forensic work, but I also provide forensic services for the jails in West Texas, and that's done through contract with the local mental health authority.
At this time, applicant would seek to have Dr. Fabian admitted as an expert in psychiatry.
Objection.
All right, he's so admitted.
Dr. Fabian, how did you originally become involved in Mr. McKane's case?
So I was approached by the Bexar County District Attorney's Office, and I'm not sure how they got my name or why they wanted to speak with me, but they approached me maybe in the fall of 2020 or early 2021. and asked if I had availability to potentially assist them in a case. I met with them, discussed my qualifications and background with them, very similarly to what I'm doing right now. And then they contacted me and let me know that they wanted me to perform an evaluation of Mr. McKane.
What all were you asked to do in this case by the state?
So, I've been doing forensic work for, gosh, almost 25 years now. And in Mr. McKane's case, there was an order from October of 2020 that limited what I could speak with Mr. McKane about and limited the types of documentation I could review and who I could even speak with about my evaluation. So I performed a general diagnostic assessment of Mr. McKane.
What was the limitation on your evaluation?
So, and you'll have to forgive me, I don't have the original order in front of me, but to the best of my recollection, the order forbade me or other experts, to my understanding, of speaking with Mr. McKane about anything to do with the, at that time, alleged offense. I also could not talk with either legal team about the offense. And there was some question about report preparation. And ultimately, I did prepare a report detailing my assessment, and a copy of that report was submitted directly to the judge.
Did the state also provide you with materials to review?
Yes.
To the best of your recollection, what generally were those materials?
Some of the materials included letters from Mr. McKane to an individual outside the jail. There was a document with a statement from a law enforcement officer made around the time of Mr. McKane's arrest. I had access to some records detailing his jail-based treatment, jail medical records, if you will. They were highly emphasized what happened in 2020. Maybe there were 250 pages of information, mostly more recent, and not as, there were some earlier records, but most were from 2020 with respect to the medical records. Then I had court records involving previous charges and convictions, to include a juvenile record from 1999, then records from the San Angelo area regarding a drug arrest and conviction in 2006, and then a domestic violence charge conviction in 2012.
I believe you mentioned this, but did you conduct an in-person interview of Mr. McKane?
Yes, I did.
Do you recall the date that that evaluation took place?
The 11th of February of 2021.
And you did write a report eventually in this case after your evaluation?
Yes.
After you completed your report, did you let the state know you had finished the report?
To the best of my recollection, I did, and I awaited additional direction. As I said, I'm not an attorney, and I didn't completely understand what I could and couldn't do, and I was sensitive about violating the order.
Was there anyone you did send a copy of your report to?
Yes, I ultimately sent a copy of the report to the, my understanding was the court coordinator, who, in accordance with the order, again to the best of my recollection, the report was to be sealed until such a time when it wasn't.
Do you recall around the time period that you had sent the report to the court coordinator?
Probably early May 2021.
Around this time period, as we move kind of into the summer, June and July 2020, I understand that you had some personal things going on in your life.
Yes, ma'am.
If you're comfortable sharing what had happened.
Oh, of course. So on the 23rd of July 2021, so almost 4 years ago now to the day, I was going to Austin. At that time, I was also serving as a governor's appointee, consulting with the Texas Department of Criminal Justice regarding care of the mentally ill inmate in Texas. And there was a face-to-face meeting. We hadn't had a face-to-face meeting in a while because of COVID. So myself and my partner, who also happens to be a forensic psychiatrist, were going up to Austin, and she was going to drive and I was going to review some materials from the meeting. And she picked me up, and her speech was not right and things just weren't as they should be. I was concerned that she was having a stroke or that something medical had happened. So called the folks in Austin and said I wouldn't be there because of a medical issue, and took her to the emergency room, where ultimately she was diagnosed with a grapefruit-sized brain tumor and admitted to a specialty hospital that day. Then she had a couple of neurosurgical procedures within the next few days and spent some time in the intensive care unit.
During this time, just to kind of orient everyone, Mr. McKane's trial proceedings are starting to begin. During that time, were you and the state in communication regarding whether they may need to call you to testify at Mr. McKane's trial?
Yes.
Was there an attorney for the, excuse me, was there an attorney for the state that you mostly communicated with?
It was primarily Mr. Del Prado.
Did you and Mr. How did you and Mr. Del Prado generally communicate?
Around this time, it was often by text, because I'm in the hospital during the day. So we commonly communicate via text.
Dr. Fabian, did Mr. Del Prado eventually communicate with you and inform you that Dr. Rambula had formed an opinion about Mr. McKane in this case?
Yes.
What was that communication?
This would have been probably in early August, and Mr. Del Prado indicated to me that...
Objection, Your Honor, hearsay.
Response?
Your Honor, we're going to ask for a little bit of leeway in a writ proceeding. There's no jury here. We want the judge, you as the court to have as much evidence as possible to understand the circumstances of how Dr. Rambula came to testify. And so we're going to ask for a little bit of leeway here. And I would also say that at this point it's not offered for the truth of the matter, but just the circumstances under which Dr. Fabian came to testify or not.
Overrule.
Okay, Dr. Fabian, go ahead. Tell us what the communication was regarding Dr. Rambula's opinion.
So this would have been in early August of 2021, and Mr. Del Prado had indicated to me that Dr. Rambula opined that Mr. McKane had antisocial personality disorder and inquired about the significance of me not reaching that diagnosis.
Did you share with him the significance of you not reaching that diagnosis?
That I didn't believe that Mr. McKane had antisocial personality disorder based on my evaluation.
After you informed Mr. Del Prado that you did not believe Mr. McKane has antisocial personality disorder, what happened after that?
So through this time, I'm standing by. Not always is trial testimony necessary, and I was awaiting direction from the DA's office about how to next proceed. I was ultimately informed that my testimony would not be necessary and that they would be moving forward with Dr. Rambula.
When you informed Mr. Del Prado that you did not reach the same diagnosis as Dr. Rambula, do you recall about how long it took before Mr. Del Prado reached back out to you?
Oh, it was pretty quick. It was later that same evening.
And to be clear, Mr. Del Prado let you know that he would not need you to testify?
Yes.
At that point, did you know whether Dr. Rambula had met with Mr. McKane personally or not?
No.
Did you eventually learn that Dr. Rambula had, in fact, not met with Mr. McKane?
Yes.
Did the state ever ask you to testify at any point in Mr. McKane's trial?
No.
If the state had asked you to testify at Mr. McCain's trial, would you have?
Yes.
Did Mr. McCain's defense attorneys ever contact you or reach out to you?
No.
If Mr. McCain's trial attorneys had subpoenaed you or asked you to testify as any part of Mr. McCain's trial proceedings, would you have been available to do so?
Absolutely. I would have wanted to get clarification on what I could say and such because of the limitations from the initial order, but absolutely I was available.
And so your testimony today is the first time this court will get to hear from you about your evaluation of Mr. McCain.
To my knowledge, yes. Yeah.
Dr. Fabian, did you become re-involved in this case at some point?
Yes.
How did you become involved?
So I believe it was your office, or maybe you directly, that reached out to me maybe a year and a half ago. Something.
Since then, were you asked by my office to review additional information pertaining to Mr. McCain?
Yes.
This is just... May I approach the bench?
Yes.
This is an exhibit we intend to offer shortly. Dr. Fabian, I'm handing you what's been marked as Applicant's Exhibit 117. Will you take a look at that document and tell me what that is?
Yes, this document appears to detail the individual PDF files that you had sent me for my review.
Does that appear to be an accurate list of the materials sent to you by my office?
Yes.
Applicant would move to admit Applicant's Exhibit 117.
Objection, Your Honor.
It's admitted.
Dr. Fabian, the information provided to you by my office, is that the type of information that mental health professionals in your field typically rely upon to reach opinions?
Yes.
Is there a general axiom in the mental health field regarding materials received in reaching opinions?
So, in general, the more information we have, the better. You're then able to kind of weigh the validity or truthfulness, consistency of records, the more pieces of information that you have. So the more information, in general, the better the opinion.
Dr. Fabian, I want to talk a little bit more about the types of information that's relevant to conducting a reliable evaluation and reaching a more reliable opinion. So first, do the ethical guidelines for psychiatrists require psychiatrists to at least attempt to conduct an in-person interview with the person they're evaluating, or at least speak with them?
So just for clarification, are we referencing the ethical guidelines specific to psychiatry or specific to forensic psychiatry? Because from a forensic psychiatrist's standpoint, the ethical guidelines that apply to my subspecialty and to evaluations like this require the provider to make an effort or ask to evaluate someone.
Why is it important to speak with the person being evaluated?
So if possible, it's good to speak with the person being evaluated because then you can weigh not only what they say, but how they say it and how they interact. And being able to listen to how someone tells their story, for example, can be very helpful to observe their mannerisms, their actions. So there's a great deal of information that can be gained both directly and indirectly from evaluating an individual personally.
Can it be important to both conduct an in-person evaluation and have collateral information when determining whether the individual you're evaluating has a personality disorder?
Absolutely.
Why is that?
So, in general, in assessments, if you can have collateral information, it's helpful in reaching a diagnosis, right? Because an individual may present only their side of things. And sometimes folks don't have a full awareness of their actions, right? Sometimes the people around them may see things that they don't. So from a diagnostic standpoint, having supporting information, particularly in a forensic setting, is important.
Are there usually certain types of collateral information you review?
I routinely will review, of course, police reports, information from the court, witness statements, medical records, things of that nature.
And that's an important part of the evaluation process.
Yes.
Can collateral information provide context to statements made during in-person interview or observations you have about the person's mental health?
Absolutely.
And if you're limited in your access to information, can that impact your diagnosis?
Yes.
May I have just one moment?
Yes.
Thank you. Dr. Fabian, I want to return to your initial evaluation of Mr. McKane. To be clear, did you conduct an in-person evaluation of Mr. McKane?
Yes.
How long did you meet with Mr. McKane for?
I met with Mr. McKane for about 5 hours total. I met with him beginning, in the courtroom actually. And we met in the morning, and then took a break for lunch and came back and met in the afternoon.
Was there anyone else present in the room with y'all?
There was at least one bailiff, was my understanding, and there may have been two, I can't remember.
Did you have the opportunity to observe any interactions between Mr. McKane and the bailiffs?
Just when he left the courtroom for the lunch break and when he returned afterwards.
How did those interactions seem?
There was nothing notable.
In your interview with Mr. McKane, what types of questions did you ask?
So for Mr. McKane's interview, because it was a general diagnostic assessment, I started by just having Mr. McKane tell me his story. And that type of unstructured evaluation allows oftentimes the evaluee to settle in, because before I ever got started with Mr. McKane, I informed him that the evaluation was requested by the district attorney's office, and that I may have to write a report, and that others may see that report, so that what we were discussing was not necessarily confidential. So that can be daunting to someone facing charges. So I started with generally emotionally neutral things. What's your name? When were you born? Where did you grow up? Tell me about school. Tell me about relationships. So I may guide with general topics, but I allowed Mr. McKane to tell me his story in a fairly unstructured, free-form way.
And what is the purpose of those questions?
So one, it's eliciting information. So getting Mr. McKane's perspective on things, right? When I ask about what someone's childhood is like, they don't necessarily present an objective viewpoint of their childhood. They present what they remember or what their childhood was like from their perspective. So it was important to get kind of what his view on these things were. Secondly, by allowing him to tell his story in a very free-form way, I was able to assess for his ability to tell me a logical, coherent story that made sense, and assess his thought processes, right? How he was thinking, how he was communicating, as well as the manner in which he communicated. So asking questions about school, upbringing, relationships with family, relationships with friends, girlfriends, work history, legal involvement.
Did Mr. McKane share with you information about his background and upbringing?
Yes.
What are some of the things you recall that he shared about his background and environment?
So, Mr. McKane was very open with me. He was very polite, which stood out because not always are evaluees polite in those types of settings. He told me about his upbringing and that he grew up in a very poor family, but his mother worked and his mother was gone a lot, so he was responsible oftentimes for taking care of siblings or watching over siblings. He talked with me about school being almost a necessary evil, that he wanted to use school to an end, as a means to an end to ultimately play professional sports. But he talked a lot about his accomplishments in athletics and what his future plans were at that time. Talked with me about his school performance and that he wasn't the best student, but that he was a good enough student to play sports. And so I would ask about general topics like school, relationships, family, and then allow Mr. McKane to tell me about that, and then ask clarifying questions as necessary.
Before we get into any kind of diagnostic impressions, what were your general impressions of Mr. McKane? What was it like talking with him and interacting with him?
So as I mentioned previously, Mr. McKane was very engaging and participatory in the evaluation. Not every evaluee is that way, particularly if I'm affiliated with the district attorney's office, for example. So he was very open and very talkative. I often just provided general topics like, tell me about your family, and he would talk with me at length without me having to continually prompt for additional information or questions.
Dr. Fabian, let's talk a little bit more about some of the things you learned from Mr. McKane by speaking directly to him. Did you consider Mr. McKane's criminal history as part of your evaluation?
Yes.
And more specifically for right now, did you consider his involvement in selling drugs?
Yes.
Did y'all discuss his selling drugs?
Yes.
How did Mr. McKane talk about that time in his life?
I'm not sure I understand exactly what time frame.
Did Mr. McKane, so Mr. McKane talked about the times he sold drugs in his life.
Yes.
Did he share with you why he sold drugs?
It was financially lucrative, and also at the same time, Mr. McKane had a significant substance use problem. And oftentimes individuals who are using the substance will sell the substance in an effort to fund their own use.
Did Mr. McKane also indicate that he was supporting his family and helping his mom and sisters out financially?
Yes, that was my understanding.
Did the circumstances of Mr. McKane's relationship with his former girlfriend, Sahara, come up?
Yes.
How did he describe the relationship with Sahara?
So when I had asked Mr. McKane about the relationship with the mother of his son, it was under this heading of tell me about your relationships, right? And he described a volatile relationship with her, and he also talked with me about the 2012 arrest and conviction on domestic violence charges. He brought that up himself.
You said he brought that up himself.
Yes.
What was Mr. McKane's demeanor like when he spoke about those issues?
So specifically with respect to the 2012 domestic violence incident, he expressed remorse that he acknowledged during his discussion with me that he had laid hands on a woman, but that he hadn't done that before and wasn't proud of that action. And one of the things that struck me about Mr. McKane's discussion, not only of the domestic violence incident, but the drug conviction in Concho Valley, as well as the juvenile conviction, was I didn't ask him specifically about any of those events. He provided them to me spontaneously. So that stood out to me because oftentimes folks who are facing significant legal charges won't talk about previous convictions or previous misdeeds, and he didn't know what I had already reviewed. I had informed him that my review had been limited, right, by court order. But he spontaneously brought up the juvenile offense, the circumstances around the Concho Valley incident and the subsequent violation of probation, having to go into a residential treatment facility because he violated probation. And then he spontaneously told me about the 2012 domestic violence incident.
Did Mr. McKane have any reason to not disclose that or trust to share that information with you?
Well, I can't speak specifically for what Mr. McCain's motivations would have been, but in general, it's been my experience that individuals who are facing criminal charges and are pre-trials particularly, right, they haven't been convicted of anything, are somewhat reticent to discuss previous convictions.
In speaking to Mr. McKane about his criminal history, did he blame others for his actions or things that happened in his life?
In general, no.
Did you find Mr. McKane presented an overly rosy or positive view of himself?
No.
Were there things in Mr. McCain's life he was admittedly not proud of?
Yes.
And you mentioned that he self-disclosed these things before you brought them up. Did you find that to be because he was proud of them or acknowledging of them?
No, he didn't talk about these incidents in a prideful way. Sometimes evaluees will do that. They'll want to convince you that they're powerful or that they've influenced others, and they'll talk about their prior misdeeds almost as a badge of honor. And Mr. McKane didn't do that.
Dr. Fabian, when you're asking a person about their experiences, is it important to try and strip away your own experiences and expectations and your own culture?
Yes.
Why?
So you want to make certain that you don't bring preconceived notions or preconceived ideas to assessments. And I think that all of us have a lens that we view the world through. And we, particularly in forensic work, but in mental health in general, the people I evaluate are often very different from me. Very different upbringings, very different lives. And I have to be careful to set aside what my personal feelings are about something when I'm speaking with someone about their life, so that my feelings about their actions or their family of origin doesn't shape my ultimate opinion.
Were there things that Mr. McKane was proud of in his life?
Absolutely, absolutely.
Is it your understanding Mr. McKane is the first person in his family to graduate high school?
And that was what he had told me.
Was that an achievement for him?
Yes.
Did he talk to you about going to Paul Quinn to play basketball for a little bit?
Yes.
Did Mr. McKane overly inflate his basketball abilities or present as grandiose when discussing them?
No.
Can you tell us more about that?
So, Mr. McKane was very matter-of-fact about his athletic prowess. His height and athletic abilities set him apart from others in his peer group, and he aspired to play professional basketball. And he told me about times when he attempted to try out for a semi-pro basketball league, but he wasn't chosen. Which I thought was interesting, because he acknowledged that he tried out, but he wasn't good enough. And when he talked about staying in school kind of long enough to make it into the NBA or to play basketball, he talked about going to play basketball at Paul Quinn, which is not a basketball power. So that wasn't it didn't seem to be inflated or grandiose at all, but more realistic.
And is it fair to say that graduating high school and getting an opportunity to go to school at Paul Quinn, that those could be proud moments for him and his family?
Absolutely.
On his family, during your interview with Mr. McKane, did he talk about his family?
Yes.
What was his demeanor like when talking about his family?
He was very proud of his family. He was proud of his mother and the work that she had done, and he acknowledged that she was gone a great deal because of the jobs that she was working. But he was proud of her for the work ethic that she had. And he was proud of taking care of his siblings. And it was actually that discussion that led to his disclosure of the juvenile incident in 1999.
And I will definitely have some questions for you about that. For now, I want to ask, during your interview with Mr. McKane, did he talk about experiencing racism in his life?
He did.
Can you tell us about that?
He mentioned that some of his experiences in elementary school, middle school, had in part been shaped by racism, and that he had come into contact with people who were racist toward him and treated him differently based on his appearance or the color of his skin. He indicated that became less of an issue as he got to be older and had more athletic accomplishments.
The topic of racism, was it something he brought up on his own or you asked him about?
I had asked him about his experience with racism.
Were Mr. McCain's reports about racism he experienced believable to you?
They seemed valid to me, yes.
Did you have any reason to doubt that Mr. McCain experienced racism, or that he at least understood he experienced racism?
I had no reason to doubt that.
Can you describe Mr. McCain's demeanor when discussing the topic of racism?
Mr. McKane was very matter-of-fact about that. He discussed, being in elementary school and being different in middle school oftentimes. But he was very matter-of-fact about it.
Was it something he dwelled on or ranted about in your interview with him?
No, and in fact, I asked him specifically about his experiences with racism, and he had made a general statement about having some difficulty in school.
Did Mr. McCain's discussion of his experiences with racism seem proportionate to his experiences?
Yes, they did.
Did Mr. McCain ever talk about getting back or seeking revenge on society or any particular members of society for the racism he faced?
No.
Have you evaluated individuals with an axe to grind against law enforcement?
Yes.
In that experience, what does that typically look like?
So, in general, oftentimes folks who are facing criminal charges, who have been involved with the legal system, will blame others for their actions. And whether that's blaming law enforcement or blaming family members or blaming acquaintances or job situation, but folks will often what we call externalize or blame others for their difficulties or experiences.
In your evaluation of Mr. McCain, was he like that?
Not in general, no.
Just one moment, please, Your Honor. Fabian, I want to talk just briefly about some of the materials the district attorney's office provided you when you were first involved in the case. Were some of in the materials provided, I believe you referenced that included some letters in the materials you received?
Yes.
At the time of your evaluation, Mr. McKane, had you reviewed those letters?
Yes.
And to be clear, are those letters between Mr. McKane and a man named John Davis?
Yes.
Did the content of those letters factor into your diagnostic impression of Mr. McKane?
There was nothing particularly clinically significant in those letters.
If you recall, what was your general impression of those letters?
Much of the letters were just back and forth. I think there was one anecdote, if you will, of police misconduct that had been raised by the person who Mr. McKane was corresponding with, not by him. But it was mostly current events and things of that nature.
And to be clear, have you had an opportunity to review those letters to refresh your recollection regarding the contents of those letters?
Yes.
I want to shift gears and talk about a personality disorder that has come up in this case a lot. Dr. Fabian, what is antisocial personality disorder?
So antisocial personality disorder is a psychiatric diagnosis made to describe an individual who has a chronic, persistent, maladaptive pattern of relating to other people or viewing the world. As I mentioned, one of the reasons you talk with someone is to get an idea about their perspective on the world or their world view. And individuals with antisocial personality disorder often lack remorse for their actions. They'll have a persistent pattern of violation of the rights of others, be impulsive, fail to fulfill obligations, things of that nature. And then an important diagnostic element with antisocial personality disorder, from a diagnostic standpoint, is that certain symptoms have to be present from a young age. So certain of those symptoms have to be present before the age of 15.
Is antisocial personality disorder also just colloquially called ASPD?
Yes.
I think you mentioned that there is specific criteria a person has to meet to be diagnosed with ASPD.
Yes.
Dr. Fabian, you mentioned that there is certain criteria regarding when they're before the age of, is it 15 or 18 that you said?
So for antisocial personality disorder, there has to be certain behaviors that are present before the age of 15. Now, in general, diagnoses of personality disorders are not made before the age of 18 because people's personalities are evolving during that time.
What is conduct disorder?
So conduct disorder is a diagnosis of childhood. So it's a diagnosis made to someone less than the age of 18. And it describes a pattern of failure to follow rules or to violate the rights of others. There are certain domains within conduct disorder.
Does there have to be evidence of conduct disorder to diagnose antisocial personality disorder?
Yes.
You mentioned that there's certain domains associated with conduct disorder. What are those domains?
There are 4 general domains within the diagnosis of conduct disorder. The first is aggression toward persons or animals. So picking fights, torturing pets, forcing individuals into sexual activity, things of that nature. Then the next domain would be deceitfulness or lying. So conning people out of things, stealing. Another domain would be destruction of property. So either setting fires or just tearing things up. Then the 4th domain is violation of serious rules. Things like, running away from home and staying out overnight, or skipping school before the age of 13, staying out past curfew or past parental rules when they need to be home, again, before age 13.
And you talked kind of about the correct, generally ASPD. Can you talk a little bit more about the criteria you're looking for to properly diagnose ASPD?
So, for antisocial personality disorder, it's unique amongst the personality disorders that they need to bring a diagnosis from childhood. So there has to be evidence of conduct disorder symptoms before the age of 15. And then if that threshold is met, then you look for evidence of persistent violations of the rights of others, failure to follow rules and norms, things of that nature.
What does it mean for something to have to be a pervasive pattern? What do you look for there?
So in general, for something to be a pattern, it has to happen more than once.
Why does the DSM require a pervasive pattern? That is, why isn't just one or maybe even two instances enough?
Because for a personality disorder, that's a disorder in someone's kind of view of the world, the way that they view themselves in the world. And it's present in multiple settings, as well as with over multiple points in time.
When you say across settings, what do you mean by that?
So an individual's symptoms of a personality disorder should show up in relationships, at work, at school, in a variety of settings, not just one area. For instance, not just problems with romantic partners, for example, or not just problems in school, but it should show up in multiple areas because individuals take their personality with them.
Is every bad act or behavior by someone an indicator of antisocial personality disorder?
No.
Why not?
So, again, isolated bad acts or antisocial acts do not a disorder make. The context is important.
The context of the act itself is important.
Yes.
In your practice, do you have experience evaluating individuals with antisocial personality disorder?
Yes.
Can you tell us what antisocial personality disorder looks like clinically? How do those conversations go with the person you're evaluating? What does it look like?
So most of my interactions with individuals who have antisocial personality disorder occur in jails. Part of my work through West Texas Centers is to provide jail-based mental health services. So I see folks who are in our county jails who have mental health issues or often behavioral issues that folks are concerned may be due to mental health problems. So I'll evaluate individuals in the jail setting. And typically, folks who have antisocial personality disorder will present themselves in a very positive light. They'll minimize the impact of their actions. They'll attribute their behaviors to other people. We mentioned externalizing and blaming others for behavior. And they won't take responsibility for, oftentimes, why they're in jail or why they're post-conviction.
Dr. Fabian, did you diagnose Mr. McKane with antisocial personality disorder?
No.
Can you tell us how you reached that opinion?
So I didn't believe that Mr. McKane met diagnostic criteria for having a conduct disorder. He had mentioned an incident in 1999 where he had brandished a knife against a family member in the context of a dispute in the home. But that was an isolated act. And in order to have a diagnosis of conduct disorder, you have to have at least 3 of 15 separate criteria that are present more than once. So persistent, recurrent pattern of behaviors. And I didn't believe that Mr. McKane met criteria for conduct disorder.
How about the other domains?
So,
Past that?
with respect to antisocial personality disorder, it's also important to know, again, the context of the behaviors. So, antisocial behaviors that occur in the context of substance use, for example, are better seen as a manifestation of a substance abuse diagnosis and not of an inherent characterologic issue, as you would see with a personality disorder.
We mentioned earlier that you also received additional collateral information from our office, including statements from individuals in Mr. McKane's life and jail records and prison records. Did that information support your finding that Mr. McKane does not have antisocial personality disorder?
Yes.
Can you talk a little bit about that?
So when I was contacted by your office, I was provided information that I didn't have at the time of my initial evaluation. So I took a look at that information, much of which were collateral sources of information from family members, peers, ex-girlfriends, teachers, an array of people. And in reviewing that information, there was no evidence that Mr. McKane had been exploitative or bullying or taking advantage of individuals in those relationship contexts. Also, I had school records that included disciplinary and attendance records. And in those school records, I think over maybe a 4 or 5 year period, there were 35 or so referrals for disciplinary problems. But they were relatively low in magnitude. And what I was looking for were things like bullying or fighting. And there was one disciplinary record out of those 34 or 35 that referenced play fighting, which seemed maybe more like horseplay than maybe true fighting or a predatory action. And then there were multiple disciplinary infractions for things like dress code violations, and not tucking your shirt in, not wearing a belt. And there was only one notation for skipping school. I think Mr. McKane had been disciplined in school for skipping 6th, 7th, and 8th period.
So for conduct disorder, you're really looking for multiple violations of truancy or skipping school.
Yes.
And for conduct disorder, you're looking for serious violations of rules.
Yes.
Does not having a belt count as a serious violation?
Not in my opinion.
I want to talk a little bit more about the juvenile incident and that incident. Did you have an opportunity to review records pertaining to a juvenile incident in this case?
Yes.
What were those?
Police and probation records around an incident between Mr. McKane and a family member where I guess Mr. McKane had set aside a hamburger patty or hamburger meat that he would eat later, and I believe a cousin or another family member had eaten that, and Mr. McKane was angry over that, and there was an altercation, during which time Mr. McKane had a knife, and his younger sister, to my knowledge, called police. Police came, and I believe that Mr. McKane was arrested at that time and charged with terroristic threat, I believe. Ultimately convicted of that and served 6 months probation.
And I believe you mentioned this earlier, but just to be clear, was this something that Mr. McKane brought up himself and talked to you about?
Yes. He brought that up on his own when I asked him about relationships with family.
That Mr. McKane brought the event up himself and the way he talked about it with you, was that relevant to your evaluation of whether he has a personality disorder?
So again, in general, most of the time folks in forensic settings, particularly pre-trial and particularly when I've been contacted by the district attorney's office, will often minimize their previous behaviors or not bring them up at all. And Mr. McKane did not know the information that I had reviewed. He knew that there were limitations on what I had reviewed because I told him it was part of the court order. So when he brought up the juvenile charge, that was a little bit unusual because that's not in his best interest. And he doesn't know whether I do or do not know about that. And he brought it up in the context of, tell me about your relationship with your family. Did you ever have trouble with your brothers or sisters or other family members? Or I'm attempting to get information about, bullying or taking advantage of family members and such. And that was how that came up.
Did there seem to be any other indication of incidents like this in his childhood?
No.
And if you remember from the records, did it appear that Mr. McKane and his cousin Ronnie had a good relationship after that?
Yes, and in fact, when I was reviewing some of the information that your office had provided me, I think there's a statement from the individual who called police, and she acknowledged that at the time she was 9 years old and may have overreacted.
In your experience working with juveniles, are you familiar with probation records?
Yes, I am.
In Mr. McKane's probation records, was one of the conditions of his probation to go to school and have good behavior?
Yes, it was handwritten on a form.
In your review of the records in this case, and in your experience, did anything about that condition stand out to you?
No. Within my daily clinical duties, one of our primary referral sources for children is through juvenile justice. So I see a fair amount of folks, who have to come see me because juvenile justice said so. So I see a lot of probation forms, and they have an array of requirements, some idiosyncratic and that are dependent upon the individual probation officer or the elements of the child's situation. And that statement in and of itself didn't stand out to me. It's kind of a blanket statement, right? Maybe when you leave home and your mom says, be good, it doesn't necessarily mean you've been bad. It just means that, your mom wants you to be good. Then when I had the opportunity to review the school records after the fact, after your office contacted me, there was not evidence of significant truancy around those times. Some of the records included an accounting of absences per reporting period, per 6 weeks or 9 weeks, I can't remember which. But during that time that Mr. McKane was on juvenile probation in 1999, he had missed maybe 1 day of school during a reporting period. The maximum was 5 days of school during a reporting period. So truancy didn't appear to be a significant issue. And remember, I was looking for that as an element of childhood conduct disorder.
Would you consider that condition to be fairly standard then, that he attends school and be good at school?
Yes, and again, it may be entirely idiosyncratic to the probation officer as well. It was handwritten onto the form, and I've seen in other cases, probation officers will say you need to go to church, for example, and that's not necessarily a global recommendation, probably good for kids, but I've seen other similar things written on the forms.
If there was evidence of conduct disorder in the early childhood records, school and probation records, what kinds of things would you expect to see in there?
So, conduct disorder in kids it's a big deal. These are high magnitude behavioral disturbances for conduct disorder. For example, there's a separate childhood psychiatric disorder called oppositional defiant disorder, which is when someone acts like a teenager all the time, right? They talk back, they don't necessarily follow instructions about taking out the trash or doing their chores, and they're just in general oppositional or defiant. And that's a lower level of behavior than conduct disorder. Because in general, conduct disordered symptoms are things that may serve as grounds for arrest were the person, an adult, or for which they could be arrested as a juvenile. For example, if you run away from home, which is one of the elements of the Diagnostic and Statistical Manual proffers as a qualifying factor for serious rule violations, you can be arrested as a kid for being a runaway.
And you mentioned things like not doing chores, not taking out the trash. If you recall from your review of the records, was there indication of the opposite in Mr. McKane's case from family members or friends that he stayed with later in his high school years, that he was actually helpful at times?
Oh, absolutely. Specifically with respect to his families. And as I mentioned earlier, Mr. McKane spoke at length about his need to step up and provide, structure and supervision for his younger siblings because his mother was out of the home.
I want to switch gears a little bit, Dr. Fabian. Is there a correlation between mental health and substance use?
Absolutely.
Can you talk about that correlation?
So rates of substance use are extremely high in the psychiatric population. Now, and individuals with certain psychiatric diagnoses will have even higher rates of substance use. For example, perhaps someone with depression, they may turn to the use of illicit substances in an attempt to self-medicate their depressive symptoms, for example. So there are high rates of substance abuse in psychiatric populations, yes.
I want to go back just a tiny bit and ask one more clarifying question. When Mr. McKane discussed with you his accomplishments in high school basketball, why is that not indicative to you of a narcissistic personality?
So it didn't seem to me that Mr. McKane's report was overblown. For example, if someone were attempting to portray their athletic accomplishments in a more favorable light, then maybe they would have said they were set to go to play basketball at Duke, a traditional basketball power, but something happened and they couldn't take the scholarship, or they hurt their knee and they couldn't go there. It just doesn't seem fanciful or grandiose to say that you're going to go play basketball at Paul Quinn College, which quite frankly I didn't know existed until I met with Mr. McKane.
Thank you, Dr. Fabian. I want to kind of shift into a different topic. Have you become aware of an incident regarding Mr. McKane on the day he was found guilty of capital murder?
Yes.
What is your understanding of what happened?
So I reviewed a video, and maybe I saw that video a couple of weeks ago, where there's no audio to the video, so there's only video. But I reviewed a video, it was a few minutes long, and it was my understanding that the video was when the verdict was being read, was my understanding. And during that time, Mr. McKane, his demeanor changed. He looked down, he began, took his tie off, began, I think, unbuttoning his shirt, and then ultimately, maybe after a minute or so, became involved in a physical altercation with several bailiffs, it appeared.
You mentioned that Mr. McKane's demeanor changed. What were some of the observations you saw of how Mr. McKane looked?
So as I remember from the video, Mr. McKane looked down and had his head in his hands, took his tie off, then I believe stood up, probably to have the verdict read, I'm assuming, And as he stood up, he began to unbutton his shirt. And then at some point shortly after that, bailiffs approached him, I believe to handcuff Mr. McKane, and that's when the physical altercation ensued.
Is what happened on the video relevant to your diagnostic impression of Mr. McKane and whether he has a personality disorder?
So again, a single act is not indicative of a personality disorder, but seeing that is a valuable piece of information, yes.
Dr. Fabian, is being found guilty of capital murder a stressful event?
I would imagine so, yes. There haven't been any studies on that, where they rate stressors in life, but I can imagine it being incredibly stressful.
Do you think that it'd be fair to say that that could be particularly stressful in a death penalty case?
Certainly.
Can you talk a little bit about how stress impacts the brain and the body?
So, for 10 years of my career, I served as the clinical director at Kerrville State Hospital, which is a forensic facility up in Kerrville, with the flooding and how everybody knows where Kerrville is. But I worked there for 10 years, and our population in that facility were all individuals who had been adjudicated by the court not guilty by reason of insanity, or who were unable to go to trial because they were not competent to stand trial. So these are all individuals who are involved with the legal system, and they all have a mental illness. So you can imagine, you put 227 folks like that in a relatively confined space and force them to live 4 people to a room, there can be conflicts. And as people would become stressed over, maybe there's a family illness outside of the hospital, right? And they can't go be with their sick mother or father or family member. They can become very stressed, absolutely. Their behavior can change, their sleep patterns can change, their eating patterns can change. And we would watch for that because those early signs of distress provided an opportunity to intervene and de-escalate the situation before it became dangerous to others.
Is there a difference between chronic stress and acute stress?
Yes. So there have been studies on stress and the body's ability to adapt to stress, and these have been in a variety of settings. And it became an interest of mine during my military career when I was responsible for taking care of people who, on deployment, were subjected to combat-related stress. And oftentimes individuals can cope with chronic stress in a better way than a single acute stressful event. So for instance, if something bad is happening to you every day, then it sometimes becomes easier to cope with than if all of a sudden there's an acute high magnitude event.
Do some individuals handle stress better than others?
Absolutely.
What kinds of things can impact how one person may handle stress better than someone else?
So a myriad of factors contribute to someone's ability to tolerate stress. Everything from childhood factors, what their upbringing was like, what their models were like, what their support is like. There are just a myriad of factors that factor into a person's individual ability to tolerate or respond to stress.
Can people be soothed if they are talked to or tended to during a stressful time?
Absolutely.
You mentioned working in Kerrville. Were there some techniques that y'all developed to de-escalate and things that you avoided doing?
Yeah, absolutely. There was actually a standardized statewide program on de-escalation because within the forensic psychiatric setting, kind of the last resort was to lay hands on any of our patients. Sometimes you had to physically restrain someone to prevent them from hurting themselves or someone else, but that was an absolute last resort. And verbal de-escalation techniques were the number one way that we avoided dangerous behaviors.
Is it fair to say those techniques were successful?
The vast majority of time they're successful, absolutely.
Did you see any indications in the video that you watched of Mr. McKane that he appeared stressed?
Yes.
Was that when you talked about his head being down and his head in his hands?
Yes.
Did you see any indication that Mr. McKane was tended to or paid attention to during that stressful time?
Not in the video I observed.
Based on your review of the video, what was the first interaction that Mr. McKane had had with someone?
It was with the bailiffs.
Not from his lawyers?
No, ma'am.
Dr. Fabian, from your in-person evaluation of Mr. McKane and review of the extensive records in this case, can you tell the court what your opinion is to a reasonable degree of medical certainty regarding whether Mr. McKane has antisocial personality disorder?
I do not believe that he does.
Do you believe he's a sociopath?
So let me ask for clarification.
This is not the best question. Let me
yeah.
rephrase. If there isn't evidence, or in your opinion, that he has antisocial personality disorder, do you believe there's evidence of sociopathy?
So, to be clear, sociopathy is not a psychiatric diagnosis.
How about psychopathy?
That's also not a psychiatric diagnosis.
Would you use either of those terms, sociopath or psychopath, when discussing someone's mental health or if they have a personality disorder?
No, they're not diagnostic terms, and they can be prejudicial.
Can it be misleading to use those terms?
Absolutely.
You mentioned that it can be prejudicial to use those terms. Why is that?
I think that words like sociopath or psychopath, number one, as I mentioned, they're not diagnostic terms. They're not a psychiatric diagnosis. And terms like that can be scary to people. In fact, there have been studies amongst how prejudicial are psychiatric diagnoses. It's one of the reasons why people don't come into treatment. And within the legal system, words like sociopathy or psychopathy are as prejudicial, if not more prejudicial, than words like pedophilia. So they carry significant negative connotation.
And Dr. Fabian, is there actually evidence in this case that Mr. McKane has empathy and cares for others?
Yes.
I'll pass the witness.
All right, let's just take a very short break, no more than about 5 minutes. versus Otis McKane, or in re Otis Tyrone McKane, present in the courtroom, attorneys for both the state and the defense, as well as the applicant. We still have the doctor on the stand. State, we're going to go to you for cross, but you had a matter you wanted to take up outside, or you wanted to take up a matter before we proceed?
Yes, Your Honor. The forensic psychiatric assessment that Dr. Fabian testified to, according to what we've researched, was under seal. We have just received a copy of it for the first time this morning, not through any fault of anyone in the court, but I want to make sure that we have an opportunity to review it before our cross. Beyond that, there also is an issue with volume 10. It looks like all of the reporter's records were tendered to us, but for some reason, volume 10 was not, which is, I believe, the hearing that was the Legrone hearing on October 20th of 2020. It's a short record, Judge. I don't think it's going to take much for us to look over it, but with those requests in mind, we would ask that we take the lunch break now and come back for cross-examination after lunch.
All right. Defense, anything?
No, I would agree with that. That's fine.
Okay. And the reason why these records were under seal is because of a defense ex parte motion prior. Is that right?
That's correct, Your Honor.
Okay. All right. So you guys we estimated about half an hour to review everything?
Yes, Judge.
All right. So what we'll do is we'll incorporate that into the lunch. We'll take an hour and 15-minute lunch break. It's about 12:15 now. Let's make it 1:30.
Thank you, Your Honor. Thank you, Judge.
You guys have a good lunch.
Judge, do you want us to leave our stuff, or?
You can.
Okay.
Yeah, it's gonna, I mean, this is it.
Court is now in session. You may be seated.
We're still waiting on the court reporter. Thank you.
apologies.
No worries.
I'm okay to leave my jacket on for a while, right?
Absolutely.
I'm ready.
All right, back on the record. State versus Otis McKane, president of the courtroom, and attorneys for both the state, attorneys for the defense, as well as the defendant, or Mr. McKane. All right, well, we last left off, state, I think we're going to begin your cross, is that right?
Yes, Your Honor.
All right.
May I proceed, Your Honor?
Yes.
Thank you. Good afternoon, Dr. Fabian. My name is Lauren Samora. If you have any questions or have any, want me to repeat, then just let me know.
Okay.
I wanted to start with a couple of questions just about your background. I know you went into your educational background, but have you testified in any hearings in any death penalty cases before?
I have. One was a pretrial competency motion where the death penalty was on the table, and then in training also participated in death penalty cases.
Okay, so other than the one that you mentioned in training, is that what you said?
Yes.
Okay, so besides those two, is this your first time testifying in a writ hearing for a death?
Yes, ma'am.
Okay. How many times have you been, or are you normally retained by the state or the defense?
You know, it's variable. It's probably about 50-50.
And in this case, you stated earlier, most of your contact was with ADA Mario Del Prado, is that correct?
Yes, ma'am.
And what was your understanding of the nature of the interview you were going to be conducting with Mr. McKane?
A psychiatric evaluation and assessment.
Okay, and unlike other ones that you have done in other cases, was this different?
So it was different because of the limitations in the court order that I'd referenced. So there were certain things that I couldn't talk about.
Here, may I approach?
Yes.
Dr. Fibino, handing you what's being marked, State's Exhibit Number 1, can you just take a look through it and let me know what the title of that document is?
So, Your Honor, may I also see a copy of it?
Of course, I'm sorry. I was going to get it to you next. Just take a look at it and let me know what the name of the document is.
So this document is titled, excuse me, Order on Defendant's Motion to Require State to Identify Mental Health Expert and to Limit the Scope of Examination.
And do you mind just taking a look through it and see if it looks like the similar order that you saw prior to your interview with Mr. McKane?
Yes, ma'am.
Okay. Did you have a copy of that order, or at least get to reference it before you interviewed Mr. McKane?
I was able to reference it. I was unable to find my copy, so I've not seen the order in some years.
Your Honor, at this time, the state would move to admit State's Exhibit Number 1, subject to any objection by counsel.
We have no objection.
It's admitted.
And you can go ahead and keep that up there. I'm going to ask you to refer to it a couple of times. Now, Mr. Fagan, like you said, you didn't have that order, but now you've been able to look at it. Does it help you refresh some of the limitations that were put on you during your interview process with Mr. McKane?
Yes, ma'am.
Okay. And did you actually have a meeting with the state or Mr. Del Prado before you met with Mr. McKane, or can you tell the court how that happened?
So I met with the DA's office before I was ever hired to participate in the case. And then I did have discussions with the DA's office prior to meeting with Mr. McKane, and the content of those, I don't remember. They may have been scheduling related, around having him available for the evaluation and things of that nature. But yes, I did speak with the DA's office prior to.
And I know it's hard and it's been some time, but when you said the DA's office, was there anybody other than Mr. Mario Del Prado that you spoke with? Do you remember?
Not to the best of my knowledge. I believe almost all my contacts were with Mr. Del Prado, if not all of them.
Okay, so Mr. Del Prado, you and he meet, you discuss scheduling, the limitations related to the order. Does that sound about right?
Yes, ma'am.
Okay. And at what point are you given some of these documents, and who gave them to you? And I'm talking about your report.
Okay, so those documents all came from the DA's office.
Okay. So they provided all these documents to you,
Yes, ma'am.
and you had an opportunity to review those prior to meeting with Mr. McKane.
Yes.
Okay. And when you were meeting with Mr. McKane, what was your understanding of the purpose of that? You said, I believe you said an evaluation, but what does that entail?
Yeah. So a psychiatric assessment and diagnostic evaluation was my understanding of the intention behind the assessment.
And what is the purpose of a diagnostic impression?
To render an opinion regarding whether someone does or does not have a psychiatric diagnosis, and if so, what they are.
And is it common for you to be supplied documents before you interview your client?
Yes.
Did you speak to any collaterals, any family members of anybody like that related to Mr. McKane?
No, I spoke with with Dr. Clem the day before, who had administered some neuropsychological testing, but no family members, no ma'am.
And did you have an opportunity to review Dr. Clem's report, or did you just speak with him?
I only spoke with him. I did not have the opportunity to review his report.
Okay. I want to go over the report with you. Now, there are some things in here. Do you need a copy of the report?
It may make things easier if I have it in front of me.
Okay.
Do you want me to get my copy?
No.
Or-
May I approach you?
Yes.
It may just make things easier if I have it.
May I approach you?
Yes.
I'm handing the witness what's been marked as State's Exhibit 2 for identification purposes. It's also been admitted under applicant's exhibit number 86 as well.
Okay, thank you.
Can you just take a look at it and tell me what that is?
So this is the report that I prepared following my evaluation of Mr. McKane on the 11th of February, 2021.
Can you just take a look at it and make sure it hasn't been altered in any way?
Actually, this copy does have some marks on it.
Oh, it does. Let me take that one back. What kind of marks is it?
It looks like someone's just underlined some things and put some things in parentheses and such.
Okay. Beyond that,
As far as the content of the report written, All the pages are accounted for, and there's no change to the content that I can tell.
Other than the documentation underlining and in the margins, is there anything else in there?
Not that I could tell.
And I do not plan to offer this, I'm just marking it as Exhibit 2.
I will ask if you're going to refer to it, and he has it, if there's writings or markings, if I can look at that version.
Absolutely.
And we have clean copies of applicants 86 if you'd like to use a clean copy. Let me grab it. Okay.
May I approach again?
Yes,
This is
y'all
a-
are gonna agree to substitute
Yes,
this
Your Honor.
document here as State's Exhibit 2 in place of the other one.
Yes, Your Honor, we would, at this time, withdraw the original State's Exhibit 2 and move to admit State's Exhibit, we'll make it 3, Judge, which is the supplement, which is the same assessment without any of the markings on it, subject to any objections from counsel.
I don't have an objection to Dr. Fabian's report, which is already admitted as applicant's exhibit 86, also being admitted as one of the state's exhibits. I'm also okay if you want to make that too, since the other one has been withdrawn and admitted. If you'd like to make that one too, I think that's fine as well. And I also have a clean copy if the court would like a copy of the exhibit as well.
Sure.
May I approach?
Yes. Thank you. So you want to reintroduce that as State's Exhibit number 2?
Yes, Your Honor.
Okay, and there's no objections to that?
No, Your Honor.
All right, it's admitted as State's 2.
Now, Dr. Fabian, you testified earlier about a juvenile instance that Mr. McKane was involved in.
Yes,
Is that
ma'am.
correct? And I believe you indicated, or you seemed to, did you actually look at the report of the offense, or how did you get the information about that offense?
Yes, I had the report of the offense and some of the probation records as well.
And do you remember how old Otis, Mr. McKane was at the time of that offense?
Probably 13 or 14.
Okay. And what was the nature of that offense?
So my understanding, based on the review of the records as well as what Mr. McKane told me, was that he'd become involved in an altercation with his male cousin in the home, that apparently Mr. McKane had made hamburger or something and the cousin had eaten the hamburger and Mr. McKane was angry about that, and that Mr. McKane brandished a knife and made threats toward the cousin to the point where the younger sister, called law enforcement.
Now, do you remember whether there was any type of violence towards the cousin prior to the brandishing of the knife?
I don't remember. Yes, actually, there was a physical altercation prior to the brandishing of the knife, as I remember it.
And do you remember what the physical altercation entailed?
I think it was something, maybe Mr. McKane had hit his cousin's head on the wall, I believe. It's a little fuzzy, but I think that's what had happened.
So, would you be surprised to know that the report had the words, Mr. McKane was very upset and was slamming his cousin's head against the wall?
Okay.
Does that sound about right?
That's consistent,
Okay. And when you say he brandished a knife, do you know what type of knife it was?
yeah. No,
Okay. What surprised you to know that it was a butcher knife?
no.
Okay. And knowing those, do you know what type of offense that would, I know you're not a lawyer, but do you know what type of offense that would be or what he was found delinquent conduct of?
Objection. He just indicated he's not a lawyer, and so it would call for speculation. If he knows, that's one thing, but otherwise it would call for speculation and outside his expertise.
I would just ask if he knows, Judge.
All right, if you know that, you can answer.
No, ma'am, I do not know. And in some of the documentation, copies that I reviewed, one of the counts had been crossed out, which added some confusion as to what the actual conviction was.
Okay. In any case, you're aware that he was placed on probation as a juvenile, correct?
Oh, yes, ma'am.
Okay. And I don't want to use different words, but do you believe that you minimized that action, that aggravated assault? Or do you believe that was actually a violent offense?
It was absolutely a violent offense.
Okay. I want to take you to page 5 of your report under substance abuse history. We talked about antisocial personality disorder, correct?
Yes, ma'am.
And in order to get to that diagnosis, in your opinion, what would you need to see?
So a chronic, persistent pattern of conduct disorder symptoms, right, that we had discussed before the age of 15. And then a similar pattern of persistent infringement on the rights of others, aggression, irritability, failure to live up to role obligations, things of that nature as an adult.
Okay. So I want to go through a little bit of this. We'll talk about substance abuse. Would that be an indication of, or using substances, could that be an indication of one of the antisocial personality disorder markers?
So it's possible, but oftentimes antisocial behaviors that occur in the context of active substance addiction are not considered part of the disorder, if that makes sense.
Well, let me ask you, you say on page 5 that Mr. McKane reported to you that he first started using cannabis at age 5 or 6 years old. Would that be one of the things to be considered when determining antisocial personality disorder?
It's absolutely a point to consider, yes.
Okay, so as early as 5 or 6, we already see one, I believe you're calling conduct disorder, is that correct?
So
Where are you?
Page 6, page 5, under substance use disorder. First, second sentence.
Thank you so much. Sorry about that.
ma'am, substance use is not a diagnostic criteria for conduct disorder.
Well, what I'm saying is that something that you would consider in determining whether or not he has antisocial personality.
Oh, certainly, that's why I put it in the report.
And that would be a mark in which column, I guess, would say.
It's an area for exploration.
Okay. And it seems to be that another area for exploration would be several of the areas that you went over in this report, correct?
Oh, yes, ma'am.
And some of those start with relationships, is that correct?
Yes.
And you spoke to him about his relationships with women, correct?
Yes, ma'am.
And I believe in his report, he talks about how ladies, he never had a problem with ladies, correct, in high school?
Yes, ma'am.
In fact, he was very popular.
Yes, because of his athletic achievements.
Did he ever tell you about any long-term relationships that he had in high school?
No real long-term, no.
Okay. Did he ever tell you about any negative relationships that he had with women in high school?
No.
The fact that he didn't have any relationships of any romantic relationships in high school, does that give you any pause?
Can you clarify by any romantic relationship?
We're talking about relationships and the ability to form relationships. Is that
Okay.
something that you consider when you're determining antisocial personality disorder?
Absolutely.
Okay. Now, he later goes and he has a relationship with the mother of his child, correct?
Yes, ma'am.
And is there any other relationships that you're aware of other than that relationship, romantic relations that he spoke of?
So I guess I need a clarification on how you classify a romantic relationship. You mean boyfriend, girlfriend, or?
Sure. I mean, anybody other than that he had a substantial relationship with that he mentioned, other than the mother of his child.
He described other relationships. The quality or depth of those relationships is not completely known to me, but since I've reviewed statements from some of those individuals.
Okay. And in your opinion, do you believe that he has issues forming relationships? I would say forming healthy relationships, maybe is the better question.
I think that Mr. McKane struggles with coping strategies, absolutely, and can struggle in forming relationships, but has done so.
And what types of relationships have you observed to be healthy relationships that he has?
So, engaging the quality of someone's relationships, right? I have to set aside what my background and upbringing is. Mr. McKane's background and upbringing was very different. So, relationships that he found positive may not be optimal relationships for me, right? But he described having relationships with people who he cared about and counted on. You know, his siblings, for example, his mother, the mother of his child. He had conflicting feelings about her, but there were some positive elements of that.
And specifically with his mother, how would you describe the relationship with his mother?
Based on what Mr. McKane told me, he loved her a great deal and respected her for the work that she did to take care of the kids.
And in fact, you talked with him about his relationship with his mother, correct?
Yes, ma'am.
And I want to page 6, if I can bring your attention to page 6 where it says relationship history. He reported that, I'm sorry, this is about his son's mother.
Okay.
And he was very open about the issues that he had with his son's mother, correct?
Yes, ma'am, he appeared to be.
And he did tell you that he had been arrested for assaulting her?
Yes.
Would that be something that you would consider as part of your ASPD diagnosis?
So recurrent violence or aggression certainly could be an element.
Now, you also looked at some other history, some other legal history other than juvenile record. You talked about the Concho County case, correct?
Yes, ma'am.
And that is a drug case, correct?
It's my understanding.
Do you know what type of drug or the drug that he was alleged to be in possession of?
I think it was both cannabis and crack cocaine. It was a penalty group 1 substance.
Okay. And was that something to consider as part of your diagnosis for ASPD?
So drug use in general, yes, it was a point for consideration.
So at this point, we have the arrest as a juvenile. Did you have an opportunity to look at any of the school records?
Not at that time. I had not seen the school records at that time.
Have you since seen the school records?
Yes.
And would it be fair to say that there were at least 35 to 36 referrals that you were able to see?
Yes, ma'am.
And I believe what you said is you believe them to, well, what did you feel about those?
They seem to be fairly low magnitude based on my review of the documentation. So things like being disruptive in class or play fighting, as I referenced on direct.
Now, you're aware that Mr. McKane did get kicked out of school, correct?
He had mentioned a suspension, yes, ma'am.
Okay, suspension, or did he talk to you about an expulsion?
Suspension.
Okay. Did he tell you how many different schools he had gone to?
We discussed the 2 different high schools, I believe Madison and then Fox Tech, but didn't speak about school changes prior to high school.
Okay, so you didn't talk about, well, did you review records from elementary and middle school?
Not prior to the preparation of the report, no.
Have you now?
I've seen attendance records and some other school records, yes, ma'am.
And do those records, do they seem to match what Mr. McKane was telling you about how he was raised?
Match in what way?
In the sense that he was moved to several different schools because of his behavior.
I don't know that to be a fact, ma'am.
Okay.
I don't know.
So in the way that it was portrayed to you, in your report, I believe it's page 3, you talk about, you discussed elements of his schooling in great detail.
Mm-hmm.
What did you talk about specifically in great detail?
He had a lot to say about school. He talked about moving, high schools, the reason for moving high schools. Talked about bullying and what types of behaviors he had endured, things of that nature.
Okay. Now he talked to you. We talked a little bit about on direct examination his feelings about racism.
Yes, ma'am.
And being victimized by the system. And I believe you said on direct that you didn't really notice a lot of that. Is that correct?
It didn't stand out strongly during this evaluation.
All right. Can you please go to page 3, second paragraph? And if you can read the second and third lines of the second paragraph, please, out loud.
The sentence beginning with Mr. McKane?
Yes.
Mr. McKane reported that he experienced racism in school where he was often outnumbered by white and Hispanic children and treated differently because of his race.
And the next sentence, please.
He reported that he learned a defensive mentality and how to survive as a result of the racism he endured.
Okay. Does that not seem to be something specific related to racism that Mr. McKane told you?
It's certainly specific to racism, yes.
And so you don't believe this direct conversation about it, you don't believe that that was something that he believed?
No, I believe that he experienced racism.
Okay. Maybe you could explain what you meant on direct then. That you didn't believe it was a factor.
I don't know if I said factor or focus, but he didn't focus on that. But he described racism, absolutely, as documented in the report.
Okay. And in the time that in this interview that you had with him, did you ever get a sense that he was paranoid or felt like others were out to get him?
No.
Would you, now that you've read other reports and spoken to other collaterals, are you aware that many people in his life believed that he that he had issues with paranoia and people following him and being against him?
I've read some of that in the statements, yes.
I want to talk about his employment history. ASPD, what would you think you would see with someone with a diagnosis of ASPD in terms of their work history?
Sometimes there wouldn't be a work history at all. Other times there could be individuals that maybe moved between jobs, often. It's a wide range. Then there are other folks who find a niche and thrive with a personality disorder in a particular job.
And how would you characterize Mr. McKane's employment history?
He worked several different jobs. There was not a single job for 5 or 10 years.
Would you say that he had very short-term jobs, mostly fast food, restaurant, things like that?
Yes, they were fairly short.
And some of those jobs ended due to his incarceration, correct?
That's my understanding.
Some of them were Concho County.
Mm-hmm.
Some of them were the assault case. Is that correct?
Yes, ma'am.
And that would that be consistent with someone with ASPD, the inability to hold a job for a period of time?
It could be. Not specifically, but it could be. There could be a lot of factors that play into that.
Now, you also had an opportunity to look at the protective order, correct? That the agreed protective order that Mr. McKane entered into with the mother of his child regarding his son?
Yes, ma'am.
And you're aware that there was violence, at least Ms. Hill, who was the mother's son, said there was violence on behalf of Mr. McKane.
Yes.
And would that be something you would consider an ASPD diagnosis?
Could be an element, yes.
Okay. Now, while he was on probation for the drug case, is it your understanding that he was arrested for the case for assault?
Yes.
Okay. So was it your understanding, or do you know if a motion to revoke his probation was filed in that case?
I believe there were some notations of that in the record, so.
Okay. So his inability to follow probation, would that be one of the factors to consider in your diagnosis of ASPD?
In an adult, yes.
Okay. And the fact that while on probation, he continued to use substances against in violation of his probation, would that be something that you consider?
It also speaks to the addiction and the substance use. So that's not specifically unique to antisocial personality disorder at all.
Someone that picks up another violent offense while on probation for a drug offense, is that something that you would consider in a diagnosis for ASPD?
Yes, any criminal offenses.
Agreeing to a protective order that involves violence, that's something that you would consider as well, correct?
Sure.
Now, since the time that you made this report, you've had the opportunity to look at additional documents provided by Grit Counsel, is that correct?
Yes, ma'am.
You've also had the opportunity to review the testimony of Dr. Arambula, correct?
No. No, I've not seen it.
You have not looked at the trial testimony at all?
No.
Did you look at, have you read any of the trial? Have you watched or seen or
So
read?
at the time, yes, I did watch some of the testimony, but I've not read Dr. Arambula's testimony, no. It's been referenced in some of the materials that I have reviewed, but I've not read Dr. Arambula's testimony.
Okay. And now that you have had an opportunity to read the documents that were provided to you by Grit Counsel, has your diagnosis or your opinion of Mr. McKane changed?
No, my diagnosis has not changed.
And this is based on the one interview you conducted on February 11th, 2021?
Yes, ma'am.
And subject-
As well as the materials reviewed.
Sorry. Yes, and subject to, and this subject to the limiting order by the judge, correct?
Yes, ma'am.
Now that you've watched some of the trial, well, let me ask this. Have you seen any of the videos, or at least any of the statements that Mr. McKane gave after trial? I'm sorry, after he was arrested.
Yes, I've seen one transcript, yes.
Have you actually seen any of the video or just the transcript?
Just the transcript.
And what was the transcript in review?
So the transcript appeared to be an interview following his arrest. The transcript itself is dated 2018, but it appears to be a transcript of what occurred after the arrest.
And in that transcript, what transpired?
Mr. McKane talked a lot about his son and relationship with the mother of his son, and then ultimately the interview progressed to the reason for the arrest and some of the information that I was not allowed to speak with him about during the initial evaluation.
Now, according to the DSM-5, there isn't a requirement that those factors that you talk about have to occur under the age of 15. Is that correct? In order to meet the diagnosis of ASPD?
So an individual has to have conduct disorder.
And at this point, we have at least an aggravated assault referral, correct?
That's correct.
With at least violent, the use of a knife, correct?
So yes, there's one physically violent incident, yes.
Okay. And in school, he was sent for fighting, is that correct?
Play fighting, not fighting or bullying.
Okay.
And it wasn't a recurrent issue. There was only one noted in the record. So again, for a diagnosis of conduct disorder or personality disorder, you need a chronic, persistent pattern of behavior.
Okay. One moment here.
Yes.
Have you ever changed your medical conclusion after you provided an initial diagnosis?
Oh, absolutely.
And what kinds of things would lead you to change your diagnosis in that case?
Additional information, ongoing observation, things of that nature. But yes, I've changed my diagnostic assessment regularly.
And in this case, what would it mean if you were to change your diagnosis? Would that somehow undermine your original diagnosis?
Well, I think by definition, if I change the diagnosis, then the initial diagnosis has simply been updated. I don't see it as a question of right or wrong. Diagnoses are fluid and change over time, oftentimes.
And in particular death penalty cases, we're talking about future dangerous, correct? That's what the jury has to consider in terms of death, when they assess death. Is that correct?
From a layman's standpoint, yeah.
Okay. And you now know that he was convicted of shooting a police officer, an unarmed police officer from behind, correct?
Yes, ma'am.
You're aware that he had multiple issues with the mother of his child, correct? That include violent behavior, correct?
Yes, ma'am.
An aggravated assault from the age of 13, correct?
Yes, ma'am.
Substance abuse from the age of 5.
Yes, ma'am.
Potentially, did he talk to you about anything that you would consider psychosis? Did he ever discuss with you any time that he had been under psychosis?
No, ma'am.
Have you since learned about any time that he's spoken, that you've learned about since then that he's been under psychosis?
In some of the other expert reports, there are some references to psychotic symptoms, yes, but I didn't see any of that when I evaluated it.
Correct. So in those reports that you reviewed, what did you see in regards to psychotic or psychosis?
Comments about the presence or absence of psychotic symptoms, unusual beliefs, declining self-care, things of that nature.
And we also have, did you, other than the one interview, you never saw the statements that he gave to police when he was, during, I think, what we call the perp walk? Do you know what a perp walk is?
I do, but I don't know the statement. There was one statement I was given by the DA's office around the time of the arrest, but I don't know the setting for that statement.
Okay. Were you ever aware that Mr. McKane made statements inculpating himself to media after the arrest?
No.
Would it be common with someone with ASPD to want to be interviewed by many media or agencies and get their story out?
I don't think that that's specific to any one personality disorder.
Okay. Would that be a sign of narcissism?
Could be.
Did you ever see any notes or see any signs of narcissism in your interview?
So Mr. McKane was proud of his athletic accomplishments, but it wasn't something certainly that rose to the level of psychosis or impaired reality testing. And everyone has personality traits. So there were some elements of Mr. McCain's presentation where he was proud of accomplishments, which I guess could be construed maybe as a narcissistic trait.
Is that the only thing that you noted in your interview with him that would have lent itself to a diagnosis of narcissism?
So the issue between the mother of his child, right, that conflict, appeared to be isolated to that relationship. So I didn't see pervasive evidence of narcissism, no.
Okay. But you also didn't see a lot of relationships, did you?
No, I did not.
And failing to have meaningful relationships is in of itself a factor of ASPD, correct?
And many other things. For example, individuals with severe substance use histories often don't have
Objection, Your Honor,
relationships.
non-responsive.
Your Honor, I think it's important that he's able to answer this question. If there's other relevant diagnoses that should be considered when deciding whether someone can form meaningful relationships, which I would argue, by the way, there is evidence in the record he has, he should be allowed to answer that.
Well, he was asked a specific question, and failing to have meaningful relationships is in and of itself a factor of ASPD, correct? He did not answer that, so he can answer that, and then you'll have the opportunity to redirect.
It can be, yes.
So the things that we've gone over, I know you were very limited in your initial, or your only interview with Mr. McKane, correct?
Yes, it was limited.
And you admit that you were really unsure about the parameters, other than you knew you couldn't talk about the specific crime, correct?
Yes, ma'am.
Okay. So, never address the actual offense. Now that you've looked at some of the individuals that did address the offense, did you have an opportunity to look at any of those?
What are you referring to
I'm
exactly?
sorry, Dr. Clem, and you said you have not looked at Dr. Arambula, correct?
Correct.
What about Dr. Crowder?
Okay, I did not read a transcript of Dr. Crowder or
Okay. So, now I want to talk to a little bit about, and I'm sorry, about the incident involving your partner.
Yes, ma'am.
During that time, we were getting close to trial. Trial had begun, correct?
I don't know if I knew that trial had begun, but I knew it was getting close.
If I represented to you that, I believe you said the 23rd was the incident?
Yes, ma'am.
Okay. If I represent to you that the trial had already begun in August, would that surprise you?
July the 23rd?
I'm sorry, July the 23rd. I'm sorry, July, if it had started earlier in July.
Okay.
Would that surprise you?
That,
Okay. And would it surprise you that punishment began July 28th, around there?
I don't know the timing now.
Okay. But that would kind of coincide with your understanding that trial was going on around the 23rd, correct?
Yes, ma'am.
And you indicated that you were on call and very aware because this was a death penalty case, correct?
Yes.
Okay. And at that time, in fact, Mr. Del Prado did reach out to put you on standby, or somebody from the DA's office did, correct?
To put me on the stand?
Or put you on standby?
Oh, on standby. Yes, I was available, yes.
Okay. And the order that we looked at, did you ever get a chance, did you read that order?
Oh, yes, ma'am.
Okay. Can you go to, let me take you to a page. I believe it's under additional orders. It should be the last page. And it should be the very first, I think it's letter A.
Okay.
Can you read that, please?
Under number 7?
Yes.
Okay. The state's mental health expert may not discuss his or her conversations, findings, conclusions, and opinions related to his examination of the defendant with any state prosecutors or agents.
And you stood by that, correct?
Yes, ma'am.
And can you continue reading to the next one?
Yes. Within 5 days after the examination of the defendant by the state's mental health expert, the state's expert shall provide his or her findings, opinions, and conclusions in a written report to the trial court for in-camera inspection.
And you did testify that you did, in fact, forward your report to the court coordinator, is that correct?
Yes, but not within that 5-day period.
Okay, fair enough. And can you continue? Can you tell me what the next one is, please?
If the report contains Brady material, the court shall release only the Brady material to the attorneys for both sides.
And you wouldn't know if that happened or not, correct?
No, ma'am.
Next step, next one, please.
The report prepared by the state's expert is to then be sealed and remain sealed until the defense calls its mental health expert to testify at trial. If the defense calls a mental health expert to testify, at that time the report prepared by the state's mental health expert shall be turned over to the state.
Okay. Now, at that point, are you aware when defense, if they ever called an expert?
I don't know those details.
Okay. If I were to represent to you that Dr. Crowder did not testify until the punishment level, the punishment stage of the trial, would that surprise you?
I don't know. I don't know how that happened, so, but it wouldn't surprise me.
Okay. So now that you've read the order, there is something that happens, correct? There is something that happens that makes the court release your report, correct? Or what you just just read?
Yes, ma'am.
And what is that triggering factor?
My understanding, based on reading this, is that it is sealed when the defense calls its mental health expert to testify at trial.
Okay. If I were to represent to you that defense did not call their expert until punishment, that would lead you to believe, or to make an assessment, that the state would have not had your report until the punishment phase. Is that correct?
I don't know how that works. I sent it to the judge's court coordinator, and then what happened after that, I'm not aware of.
Okay, but you're reading the order, correct?
Oh, yes.
And so if I tell you the defense put their expert on in punishment, what would that would trigger what?
I'm assuming, and again, I'm not a lawyer, so I'm just reading what's here, but I would assume that that would be testimony at trial.
Okay. Would you assume that the state at that point is after that testimony, when the defense puts their witness on, their mental health expert, would you, reading that, do you interpret that to mean that that is the first time the state is going to have an opportunity to look at your findings?
That would be my layperson's reading of a court order.
Okay. So we're on the 28th of July approximately, and we get to the punishment phase. At this point, have you already spoken to the DA's office about the medical issue of your partner?
Oh, yes. Yeah, I notified the DA's office the morning of the 23rd.
And you said you had a conversation with Mr. Del Prado, and you discussed the contents at that point of your report, correct?
Not when I was notifying him of the medical issues in the family.
Okay,
But
at some point.
yes, at some point in late July, early August. Yes, ma'am.
Okay. And at that, how many times did you speak to him?
Oh, during that time frame?
Yes.
I probably spoke with him on the phone maybe 3 or 4 times. There was quite a bit of conversation by text, but I spoke with him several times.
And at some point, you testified earlier that he indicated that you wouldn't be needed to testify, correct?
That's correct.
And did anybody on the defense team ever contact you?
No, ma'am.
Did you know who the defense attorneys were?
No.
Did you ever speak to Dr. Mercado?
No.
Did you ever get a response from Dr. Mercado?
Response.
Let me say, did you ever reach out to Dr. Mercado?
No, I never reached out to Dr. Mercado.
Okay. Do you know who Dr. Mercado is?
Based on review of records, Dr. Mercado is a neuropsychologist, I believe, or a psychologist who administered some testing in 2017.
And did you look at that report in preparation for your testimony today?
Yes, I have seen that report.
And when you spoke to Mr. Del Prado, you testified earlier that you did discuss the differences in your findings versus Dr. Arambula's, correct?
Yes, ma'am.
And was there any issue with Mr. Del Prado's tone, or was it a pleasant conversation?
Oh no, it was very pleasant. I was extremely appreciative of the support from the DA's office, given everything that was going on, family-wise. No, they were all very, very pleasant, very cordial conversations.
Did you have any sort of did you feel like you were trying to be swayed in any way to change your opinion?
Absolutely not.
Was there ever any indication that because you weren't testifying a certain way that you were not going to be called by Mr. Del Prado?
No, it's not uncommon for me to do an evaluation and not be called to testify at trial. So,
is it uncommon? Well, you said you've only done one death penalty case.
Yeah, I don't do a lot of these. No, ma'am.
Okay. Are you aware that it's very common for defendants not to speak about the offenses that they're charged with?
That wouldn't surprise me.
And that would be by the advice of their own counsel.
Or
Objection.
If you know.
We're getting
yeah,
into
I
speculation.
don't know.
I'm sorry, and if I make an objection, I think it's important for me to look at the objection on the record, but I appreciate reframing the question if it avoids the objection, but.
Yeah, and let me just admonish this witness as well. I know we're not used to testifying every day, but if there's an objection, an attorney sends up an objection, refrain from answering until we tell you whether or not you can.
Yes, Your Honor.
Yes, sir.
So at the time, you're going through a, you and I mean, by virtue of your partner, going through a medical emergency, correct?
Yes.
Did Mr. Del Prado ever indicate that why you wouldn't be called?
No.
Now that you've had an opportunity to review reports, you're aware that other experts, Dr. Romberly came to a different conclusion, correct?
That's my understanding.
And he was able to look at, if you know, do you know what documents and he was able to look at?
No, I do not.
Okay. Nothing further, Your Honor, pass witness.
Honor, may I have just a few minutes here?
Sure, do we need to take a short break?
Oh, that would be great,
All
yeah.
right, let's take a short break.
Wait, what?
Good luck.
Have it recorded. Thanks, Judge.
Yes,
Good luck.
sir. Thank you. You guys ready? Yes. All right, back on the record, State of Texas versus Otis McKane, President of the Courtroom, attorneys for both the state, the defense, as well as the defendant. I think defense applicant, your redirect.
That's correct.
All right, you may proceed.
Dr. Fabian, the state went over some of the limitations that were in the court's order pertaining to your evaluation of Mr. McKane. And if I understand correctly, the one limitation really was not to get into the facts of the offense. Is that correct?
Yes, ma'am.
But to be clear, there were no other limitations regarding what you could get into with Mr. McKane, so that you were able to talk to him about his family, his background, environment, and his other criminal justice issues.
That's correct.
Dr. Fabian, there was a big discussion about substance use, including perhaps even as a young child. Can you just reiterate why you ultimately diagnosed Mr. McKane with a substance use disorder versus antisocial personality disorder as it relates to substance use?
So the two diagnoses of themselves, they're not mutually exclusive. Okay, someone can have antisocial personality disorder and substance abuse. But in Mr. McKane's case, the antisocial type behaviors that surround substance use, procuring the substance, using the substance, were better accounted for by his significant substance abuse problem that started when he was a kid.
I want to talk about the ability to have meaningful relationships. What are you looking for in terms of the ability to develop meaningful relationships in considering a diagnosis of antisocial personality disorder? What sorts of relationships do you look for?
So there are some subjective elements of assessment, of course, right? And what makes a meaningful relationship versus, I guess the opposite of that would be a shallow, superficial relationship. And in reviewing the records, primarily the declarations of individuals in Mr. McKane's life, they believed they were part of his life, and they represented a significant relationship. What he told me was that the relationships were significant. And I don't know that length of time of a relationship, particularly in high school, is necessarily indicative of the overall quality of the relationship or the perceived quality of the relationship.
Do only romantic relationships qualify as meaningful relationships as it relates to assessing for ASPD?
Oh, absolutely not.
Did you see evidence in Mr. McCain's case that he has healthy relationships?
Yes, and again, it's a slippery slope, engaging, healthy versus not. But Mr. McCain perceived those relationships as positive. He talked about family and how important family was to him, how important his son was to him. And so, yes.
And we've talked at length about how you had many declarations from individuals in Mr. McCain's life. And did that include his mom?
Yes.
His sisters?
Yes.
Girlfriend from high school?
Yes.
Friends from high school?
Yes.
Including friends that were male in high school and friends that were female from high school?
Yes.
In fact, we heard from one of those female friends today.
Yes.
Did that information indicate that it was also their perspective they had a meaningful relationship or a healthy relationship with Mr. McCain?
Yes.
Just briefly, we talked about how Mr. McCain discussed experiencing racism with you in his proportionate discussion of that. But is it fair to say that having experiences of racism can, for some individuals, be a traumatic experience?
Certainly.
Is it unusual for individuals to develop strategies or coping mechanisms, whether they're aware of it or not, when they experience traumatic experiences?
Oh, absolutely not. Mr. McCain's description of racism included his coping strategy. I think that one of the things that he told me is some people will be racist and I'll be black, or words to that effect. So it was an acknowledgement that racism existed, and he formulated a coping strategy. So yes.
Dr. Fabian, were you able to review records and information pertaining to different incarceral settings that Mr. McCain has been in?
Yes, ma'am.
And did that include his time at the Bexar County Jail, his time at now Polensky, but also his time in a rehab center, which is still an incarcerated setting in Concho County?
Yes.
What did those records reveal to you?
Which one specifically, or just in general?
In general. So
the Concho County records indicated that Mr. McCain had violated some rules in that facility, two, to be exact. The treatment in that rehabilitation facility has different phases, and people will complete phase 1 and move to phase 2, complete phase 2, go to phase 3, etc. And in phase 1, which is the first phase, Mr. McCain was late to class. Then later in the phases, I think it was phase 5 at Concho Valley, Mr. McCain had a job in the community at McDonald's. And that's a common part of residential type treatment centers in the justice system. Whereas you get closer to completing the program, you'll have a community-based job. And I think that he was disciplined for using profanity at work.
did Mr. McCain complete the program?
Yes.
Did he complete the program on time?
Yes, and when we talked, he was very proud that he was one of the few people who did.
The two little infractions you mentioned, were those serious in nature to you?
No. Then there were other records as well?
Yes. In the Bexar County records and even his Polensky records, what do those indicate to you about his behavior in those incarcerated settings? So in the Polensky records, there is a notation where Mr. McCain has been disciplined, but for masturbating, and not in a provocative way. So for instance, sometimes in incarcerated settings, inmates will masturbate in front of female staff members or things of that nature, and that wasn't the issue here. So he was written up for masturbation at Polensky. And then the review of the Bexar County records didn't show anything significant in his time in Bexar County. For the Polensky records, you mentioned the one disciplinary, and was that in fact one disciplinary?
That's my recollection based on the review. Some of the pages were really light, but yes.
In your review of the records, let me ask this. If you're reviewing records of an individual with antisocial personality disorder, a robust ASPD, What types of things would you expect to see in their disciplinary records in incarcerated settings?
So recurrent rule violations, victimization of maybe vulnerable inmates or peers, aggression towards staff, either physical or verbal, disruptive behaviors within the jail, such as overflowing a toilet or plugging a sink and flooding an area, things of that nature.
Do you see anything like that in Mr. McKane's records?
No.
There was a discussion about different schools Mr. McKane attended. Did the school records you reviewed or any in the records you reviewed indicate he was expelled or moved around from schools because of behavioral issues?
No.
Did anything in the collateral information indicate that Mr. McKane had to move around from schools because of behavioral issues?
No, ma'am.
If you recall, does the collateral information indicate that one reason Mr. McKane changed schools is because he changed neighborhoods? His mom moved them to a new neighborhood or different neighborhood, and he changed schools?
Yes, ma'am, that wouldn't surprise me.
May I have one moment, please?
Yes.
Let me have a couple more questions. The state has asked you about numerous issues that could factor into a diagnosis of ASPD. To be clear, did you consider all of those things that the state went over in their examination and that's in your report when you did not diagnose Mr. McKane with ASPD?
Yes, ma'am.
There was a discussion about your communications with Mr. Del Prado in this case. To be clear, was one of the last communications from Mr. Del Prado him telling you that Dr. Arambula had diagnosed Mr. McKane with ASPD?
That was one of the communications, yes.
And him asking you why you did not reach a diagnosis of ASPD?
Yes.
And to be clear, was it that the last communication before, a couple hours later, he informed you he would not need you to testify?
That's my understanding and recollection.
That's all I have.
Just a few follow-up questions. Dr. Fabian, I want to go back to the health relationship topic.
Mhm.
I have the index of materials, which is Exhibit 117 of the applicant. All of these post-conviction, all of these declarations that you received, those were all received after the conviction, correct?
Yes.
And so you're basing these healthy relationships on these declarations. You did not have these prior when you wrote your report initially, correct?
That's correct.
Okay. Would it surprise you that his sisters in this case were subpoenaed to testify on his behalf?
It wouldn't surprise me.
Would it surprise you that they had to be subpoenaed because they would not show up on their own?
Objection, Your Honor. That is not in evidence, and it's actually, with all due respect, it's going to be a misconstruing of the evidence in this case.
Judge, we've asked to take judicial notice of the reporter's record, all of the past proceedings. That was something that came into during the trial. That was something that was discussed. So I believe I can get into that.
All right. Overall.
But I'm really sorry, I understand the court made a ruling, but where in the record does it indicate that the sisters what you're talking about. Where is that in the transcript?
If we want to take a break, Judge, I can show them.
Okay, let's take a break so you can show the applicants.
Your Honor, I'd like to withdraw that last question and I'll rephrase.
Okay.
I know you haven't gotten to look at all of the documents for the writ of habeas corpus. Have you had an opportunity to review the responses of defense counsel, Mr. McKane, his trial counsel?
No, ma'am.
Okay. If I were to tell you, applicant's exhibit 112, which is an affidavit of Ray Fuchs. Do you know who Mr. Fuchs is?
I'd have to refresh my memory, but
Okay. Do you have that order up there still?
yes, ma'am.
Okay. And that was the order that you received, correct?
The court order?
Yes.
Yes, ma'am.
Can you go to the last page?
Okay. Mr. Fuchs is listed as an attorney for the defendant.
Okay. And in fact, that order has all of the attorneys for Mr. McKane, is that correct?
It has, I guess, 3 attorneys. I don't know if that's all of them.
And who are they?
A Mr. Joel Perez, Raymond Fuchs, and a Daniel De La Garza.
Now, you haven't had an opportunity to look at Mr. Fuchs or Mr. De La Garza's affidavits, have you?
No, ma'am.
Okay. If they were to testify that they had to subpoena applicant's sisters because they were not cooperative, would that surprise you?
I really don't haven't.
I'm going to object because it calls for speculation. Asking whether it would surprise him, he doesn't know that dynamic. He's not privy to the dynamic between trial counsel and the lay witnesses in this case. That is honestly in the purview of this court's decision in assessing the ineffective assistance of counsel claim is that relationship. Dr. Fabian is not privy to it. He doesn't know anything about it. So whether he's surprised or not surprised by the fact that witnesses are subpoenaed, which is normal, by the way, is speculative.
You can rephrase your question.
Thank you. When you're talking about healthy relationships, you've reviewed the declarations of the sisters of Mr. McKane, have you not?
Yes.
And you would testify that they have, in your opinion, a healthy relationship, correct?
A positive relationship, yes.
And if, in your opinion, if you are facing a charge of capital murder and you have healthy relationships, would you expect those individuals to show up and testify on your behalf?
I don't know that that's within my area of professional expertise, but I would hope that people would testify on my behalf, yes.
Okay, let's put it this way. if you have a healthy relationship with your family and they want to, and you expect them to help you, as a defendant, if they were uncooperative, would that maybe change the perspective of your thought of the relationship and the healthiness of it?
Your Honor, I'm gonna object to speculation again. We're getting pretty far afield from what he's reviewed. He is aware of the contents now of Mr. Fuchs' affidavit. He has he has his sister's declarations, their perspective of what happened. But this is now speculative.
I'll let you ask that question as it relates to this case and his evaluation of it.
Mr. Fabian, I'm going to read you what's page 3 of applicant's exhibit 12, which has been previously admitted.
Okay.
And all I'm going to ask in your opinion, well, let me read you this first, and then I want to ask your opinion on what I've read, if that would reflect a healthy relationship or a supportive relationship. And Your Honor, this has already been admitted, previously admitted. Page 3, applicant includes these narrative statements of his sisters regarding health issues applicant exhibited prior to the incident offensive. However, when summoned to the courtroom and requested by trial counsel to testify to the same, they both refused. Rather, they informed counsel they would not testify and certainly would not testify about any of applicant's mental health issues because of what they perceived was an attempt to attack their applicant's mother. Trial counsel talked to applicant about this problem and were again informed that he would disrupt the proceedings if he pressed on with this matter, and we were told not to talk to his sisters anymore.
I really don't have an opinion on the quality of the relationship based on that information.
Okay. What about if his mother, do you believe that he and his mother have a good relationship?
In general, yes.
And if she were called to testify, or when she was called to testify, I'll read you another portion of this. Applicant's sisters were not the only family members who were uncooperative. When Sandra McKane, applicant's mother, was called to testify that day, she told us that she had no transportation and was not going to go to court. Trial counsel sent the investigator to her house to bring her to court. She informed the investigator that she did not want to testify because when she testified at a hearing, she was not comfortable with people knowing what she said. It was not until trial counsel explained a writ of attachment that she finally relented. Do you know what that means?
No, ma'am.
Okay. Do you know, well, you know that they asked her to come testify on his behalf, correct? At least
Okay.
according to his counsel.
But the part about writ of attachment and things like that, no.
Okay. But you understand that part, correct?
Yes.
And that she refused to, correct?
That's what you had read to me, yes.
Now, is that consistent with someone with a healthy relationship with their parents?
I couldn't comment on that. That's an isolated incident. I couldn't comment on what that meant necessarily.
And I want to talk to you about the narcissism aspects that we talked about. One of the things that you looked at according to the exhibit that Brick Counsel filed would be applicant's exhibit 117. Now, in here it does say you were provided the testimony of Michael Arambula. Are you saying you did not review that?
I did not review a transcript of testimony for Dr. Arambula.
But you did review, or did you review the McKane interview with SAPD Detective Dr. Duke? I'm sorry, Detective Duke.
Yes, I did.
And in that interview, do you remember Mr. McKane saying that he was the best basketball player ever?
I remember him talking about basketball, yeah.
So saying something like that he was the best basketball, is that a sign of narcissism?
I don't think in and of itself it's diagnostic of narcissism, no.
Okay. Do you know up until 2018, Mr. McKane is still maintaining his innocence for this?
I didn't.
Okay. Would that be a sign of narcissism?
Not necessarily.
Now, you mentioned some of the incidents and jail that Mr. McKane went through, and I believe you said they weren't, what did you say about Bear County Jail? That there was nothing of substance, or?
Nothing stood out to me based on my review of the medical records and such.
I'm talking about the disciplinary records.
Okay.
Did anything stand out to you in Bear County?
Nothing significant.
How many times do you believe, or do you remember, that Mr. McKane was written up in Bear County?
I don't remember that. So
Do you remember an incident where he threw a tray at someone?
vaguely.
Do you remember an incident where on February 15th of 2012, he claimed that he was going to whip somebody's ass?
Okay.
That he refused to do certain chores that he was supposed to do?
Okay.
Do those seem not important to you or not significant?
So it's a question of magnitude, and I didn't see those as high magnitude events.
Okay, but they are consistent. You're looking for, I believe you said with ASPD, he has consistent issues with authority, not following instructions, violence, those kinds of things. Now that he's incarcerated, those activities are continuing to occur. Would those be in line with ASPD or narcissism, for that matter?
Not necessarily. They could, but individuals without personality disorders can exhibit similar behavior as well.
Okay, so it could be either or.
Certainly.
Are you aware that Mr. McKane had an incident at the hospital when his son was born?
No, ma'am.
Did he discuss with you his thoughts that his cousin Jerome was cheating on him, or cheating with the mother of his child?
No.
Are you aware that he requested and yelled for a DNA test at the hospital after the baby was born?
I'm not aware of those details.
There's a lot of things that you aren't aware of, correct?
I think probably in general.
I'm sorry,
but
related to this case.
I don't know everything that happened.
Well, you weren't present for the trial, correct?
That's correct.
You saw the video, we didn't cover it, but after the verdict, you saw that incident, correct?
Yes.
And did that cause you any concern that potential future dangerousness of Mr. McKane, that instance?
Yes.
Okay, and why did it?
So all violent acts, should be considered, certainly in an assessment of future dangerousness.
And that one specifically, why was that one, or was it specifically important?
That particular event stood out to me based on the setting and the circumstances. So that's an extremely stressful situation. Didn't appear to be predatory, for example.
Okay. So, I know you said you viewed the video, you said only one time, correct?
Maybe twice.
Okay. In your opinion, or I mean, in your recollection, do you know how long from the time the verdict was read, approximately, until the elbow was thrown?
Maybe a minute.
Did you see any activity that Mr. McKane was doing that was out of the ordinary?
Took his tie off. Began to unbutton his shirt. I mean, that's unusual behavior. Began to look down, had his head in his hands. So yeah, there were some changes to his body movements.
Are you aware, or are you aware that taking off a shirt or pulling off a shirt can be a precursor to a fight?
Oh, certainly.
So is that consistent, or did you even consider that part?
No, of course. But 45 seconds to a minute is not a lot of time to process something. So that still falls into the realm of behaviors driven by affect, emotion, stress.
So being that he has just been convicted of capital murder, and he's been surrounded by law enforcement and officers of the court, you don't see that as a sign of future dangerous, or you do?
I don't have an opinion regarding future dangerousness with respect to that act.
Would that be something to be considered for future dangerous?
Sure.
Is that post-verdict behavior consistent with the behaviors that you've learned of Mr. McKane since he's been convicted?
I don't know if I understand the question.
Of all the things that you've read and learned since his conviction, is that behavior consistent, after the verdict, is that consistent with the behaviors that you've read?
No.
So I'm not trying to be argumentative, but is being angry at receiving a verdict and lashing out, is that not consistent with his arrest as a juvenile, lashing out after his cousin ate his hamburger?
I don't know the motivation for the action in the courtroom.
Is that not consistent with behavior of throwing a tray at an individual and saying, I'm going to kick your ass?
I don't know the motivation for that behavior either.
But you know that when Mr. McKane gets angry and he doesn't like the outcome, he reacts.
I know that Mr. McKane has acted out.
So
But
those are consistent, correct?
I don't know the motivation. Motivation and context is important.
Nothing further, Your Honor.
I have 3 questions. They're short. Dr. Fabian, is it your understanding that Mr. McKane was at the Bexar County Jail for almost 5 years waiting trial?
Yes.
The few incidents cited, is that pervasive and persistent?
No, they were isolated.
You were asked a question and read statements from Mr. McCain's trial lawyer, Mr. Ray Fuchs, responding to ineffective assistance of counsel claims. The statements that were read to you, is it fair to say that those statements are indicative more of Mr. Fuchs' relationship with Mr. McCain's family rather than Mr. McCain's relationship with his family?
It's possible.
No other questions?
Nothing further.
All right, if you don't mind getting the documents, putting them on the ledge for the court reporter, you are excused.
Your Honor, actually would like to keep it subject to recall.
You'll be subject to recall. All right, you can call your next witness.
Your Honor, that is all we have for today. Our other witnesses, we do need to reach out to them to see if they made it in on their flights. But that is all the witnesses we intend to call today. If we have a little bit of time, though, I would ask, we can do this off the record too, it's more of a housekeeping matter, but we'd like to spend a little bit of time making sure we can connect to the technology in the courtroom for tomorrow, the TV. And I know that will take up a little bit of time, but those are the witnesses that we do have for today.
Okay, let me check to see what time. Did y'all get a time for tomorrow?
I don't think so. There might have been one a while ago, but I think it'd be good to get an update to make sure we know exactly the right time to be here.
Okay, let me.
The court coordinator knows all.
Yeah, she's got the schedule. You got enough witnesses for tomorrow?
Yes. I expect them to take the whole time allotted.
No, we do have mental health court dockets in the morning, right?
That's right.
I didn't tell them to come back here 1:30. And I got okay. All right, tomorrow 1:30 till the end of the day.
Thank you.
Did you want house? We're now on the record, right?
Right.
Yeah.